for 16.
What is the subject matter?
Subject matter is covered by Supreme Court.
Huh?
Covered cases of Supreme Court. Let us
16th.
16th of 16/6 May.
All right, 16/6.
May I'm paying listing my lot on behalf of regarding non-payment of my lot, medical reimbursement bill, my with sanction amount, my lot. So my lot on my lot 21st June, my lot. In the last occasion, my lot, your lordship was my lot asked me to make mention if I have my lot rule, my lot. Now my lot I have paid my lot rule, my lot.
You have what?
My lot rule for my lot
Rule.
yes, my.
21st is a Sunday.
Sorry, my lot. 22nd, my.
22nd is this for admission.
My lord.
Last week will be for motion only.
Then 23rd, my lord.
Huh?
Then my lord, next
After vacation.
my lord, there is urgency, my lord. The petitioner is my lord, suffering, my lord.
So you are asking for 21st is a Sunday. Last
My lord, then my lord, prior to my lord.
prior to 16th.
Of this.
I would like to mention number 17. Taking consent from the other side. Some person
17.
17.
Item 17 on the request made on behalf of Mr. D. Bora, counsel for the petitioner, stands deferred to be listed after vacation. In the month of July, on a date to be fixed by the registry.
I filed an IA lordship for correction of some typographical error on the recording the dates. The matter can be taken up next week.
Monday.
Right.
When was it last listed? 3/6/25. Huh? Let it come in July, August. 27 July. 27 July. Huh? Oh, urgency for 1 year it is not there. Suddenly you have urgency. Why? What is the urgency? Not next week. After in July 27. Yes.
May I please the lordship, my lord, I beg to mention item number 29 and 30 on behalf of the health department. My lord, I have taken consent from the petitioners in both the cases, my lord. My lord, the matter is actually under process, my lord, so we need some time, my lord.
29/30 on the request of the Standing Council Health. Matter stands. What do you say? Matter stands deferred as is submitted. The government is contemplating to undertake. Government is contemplating to ameliorate the grievances of the writ petition. It plays for 4 weeks' time. Mr. M. Haloi. K.M. Haloi appears for the petitioner. Item 30, that is WPC 6375. Accordingly, release this matter again after 4 weeks on a date to be fixed by the registry. 14 July. Oh. 27 July.
Obliged, my lord.
For listing one contempt matter for orders.
Contempt for orders. 17.
Wait, please, my lord. Prayer for listing of a motion matter for Monday,
When was it filed?
yesterday. Suspension
Yesterday.
matter. Most about the year is due to end, my lord. No review has been done.
All right, Monday.
I'm so obliged.
I beg to mention for listing a matter for admission also. After admission, after vacation, any date.
27 July.
I please your lordship. With the consent from the other side, I beg to mention item number 12. As my senior Mr. S.K. Mehdi is out of state.
Item 12 on the request made on behalf of Mr. S.K. Mehdi, learned CBC, matter stands deferred. Be listed after 4 weeks.
The beg to mention item number 13 also. Consent of the other side also. Matter may advance for the day also. My senior is
Item 13 to be listed after vacation. After vacation.
May I please? Lord, I beg to mention item number 11. This case, we want to file additional activity. Kindly, my lord, after vacation and along with.
After item 11, the request made on behalf of by Mr. A.K. Azad, matter stands deferred to be listed
But I
after
have-
4 weeks.
I have another there also, my lord. This case, my lord, due to some formal defects, my lord, we want to file amendment.
You file amendment,
My
so
lord,
you
my-
don't
I'm
need
a-
any prayer,
I'm a-
permission.
I beg
For orders. Why?
matter are related to provision of service.
17 July?
I beg to mention a listing of an or admission matter.
Admission matter. Admission matter, 29 July.
Similar matter, same pensionary venture. Another matter, same
29 July.
plus.
May please, your lordship, I beg for listing the matter, lordship, matter 22 matter, lordship. 22, pensionary benefit, lordship,
29 July.
oblige, lordship.
Which one?
I will
No, not before vacation, after vacation. What date we had given? 17. 17.
My lord, we have been led by Dr. Ashok sir of this matter. However, lordship is before another court now. Lordship, may kindly pass it over for timely.
Last week, my learned it submitted,
It's timely.
Time being.
May please, your lordship. In item number 2, your lordship, I have to file reply, your lordship. Some time may be aggregated, may be fixed after vacation, your lordship.
The request of the counsel for the petitioner, matter stands deferred to be listed after 4 weeks, enabling him to file a reply in WPC 1089 of 2020.
3-7.
Who's appearing for 3?
I am appearing, your lordship.
You are filing a reply in 3 also.
I have filed already. 3 I have.
Let both these matters be relisted again in the, after 4 weeks.
Oblige. Lordship, my scenery is on legs, lordship. Password for time being, lordship.
Time being.
Oblige, lordship.
petitioner is aggrieved by the non-regularization of his service, thereby rejection of the pensionary benefit of the petitioner lordship. The pleadings are already completed. We have also filed a reply. Department standing counsel.
You are working as what?
Lordship, initially I joined as master role worker. Lordship, I retired as work child section assistant. Lordship, my appointment is lordship as a master role worker in the year 1986, and subsequently in the 1990.
You are asking for regularization in which post?
Lordship, work child section.
You are regularized as a master role.
No, lordship. From the master role worker, the petitioner was again appointed as work child.
Where is the appointment of the master role?
Master role lordship, I have not annexed the master role lordship. I have annexed the appointed work child assistant, that is page number 15 lordship.
Section assistant. Then
Lordship, what happened, Lordship, in the year 24/9/1991,
what is the claim for regularization? What is the basis?
the petitioner, 1991, the service of the petitioner was terminated, Lordship, and the petitioner approached this honorable court, and this honorable court on 29/1/1993, while resetting the petitioner, further, Lordship, come to page number 20, Lordship. That is the judgment where, and the Lordship, the relevant paragraph is, Lordship, page number 21, Lordship, from the last paragraph. The expression "a fairly long spell" has been translated by the Supreme Court into 2 or 3 years. Keeping in view of the above decision of the Supreme Court, the petitioner is disposed of on terms and following orders. The state government of Assam is to verify the vacancy position of the category of daily laborer, casual laborer, master or worker in the Karbi Angan division, and frame a scheme in a fair and just manner for regulation of 18 petitioners named above, having regard to their length of service and other relevant conditions, including prescribed qualification, if any, while absorbing the petitioners on regular basis. Each bar shall be waived and reservation shall be complied with. The scheme shall be framed within the 6 months from declaration. Thereafter, petitioner Akin joined Lordship, and he has been doing the service till his superannuation in the year 31/12/2020, Lordship. And after retirement, Lordship, when the petitioner submitted his pension paper, the same was been rejected, stating that the service of the petitioner is not regularized, therefore the petitioner is not entitled for the pension. That is the case of the, and I'm paying for the regulation of the service of the petitioner. And Lordship, the open bus has been set aside by the Honorable Supreme Court, Lordship.
There is no direction with regard to work charge in the apex court order.
Work charge shall be put in the different footing, and the work charge can also claim for the pensionary benefits or regularization.
But there is no direction that you should be regularized in terms of the judgment of the apex court. Did you frame a scheme in terms of the directions? Any scheme frame?
Government. Scheme, government is equal to frame the, my lord, scheme, my lord. We are only the, my lord, we have the executive power, my lord. The government,
Any scheme frame?
for declaration of works.
Irrigation department.
It is the government.
Who's for irrigation department?
Miss Dean Looks.
So what is the claim? What is the basis you are asking for regularization? On what proposition of law?
For this, this recent judgment of the, though there is no direction of the work charge, but a work charge has been putting in the differences from the master roll worker, and Lordship, they can claim their regularization.
We can claim, you go and claim.
My pension paper has already been rejected, Lordship.
Then
Lordship,
what is the base? That's what we are asking you. On what basis are you building up your claims for a direction that you should be regularized, enabling you to earn your pension? Yes, government any scheme? Come to page number, where is the judgment of this court? Page number 21. Come to page 21. Last paragraph.
I want to say that, appointment and other matters of the grade 3 and grade 2 employee of the 6 area of Autonomous Council as completed by the Autonomous Council. Why they are not appointed at the regularized at that time, but we have to.
We are asking you, is there any scheme framed in terms of the direction of the court at page 21?
No, my lord.
No scheme.
We have no information in this regard, my lord.
No, who will have information? It is the government who is supposed to frame the scheme.
It is this the 6 schedule area, the appointment and other matter of 6
The
schedule area.
direction is to the government, not to the 6 schedule area. Read that order. Page number 21.
But my lord, it is time burden.
Why?
This matter is to implement the scheme within 6 months from the date of the judgment, my lord. Now it is 30 years. 30 years past, my lord.
The department.
The petitioner could have appeared before this, approved before this court after 6 months from the passing of this order, my lord. It's time burden.
Department communication was going there. They have also annexed one later, lordship, that is page number 76 on the in their affidavit, lordship. Department lord. Funds to the subject cited above, I have the order that has been sent by the Baithalanko Division Irrigation to the Chief Engineer Irrigation Assam. With reference to the subject cited above, I have the honor to submit here with pension paper duly filed in respect of Sri Narayan Chandra Bora, that is the petitioner here also. Work charge section assistant under the establishment of the underside on 31/12/22. In this connection, it may be stated that there is no vacancy against the sanction post of the section assistant under the establishment of Kazirangan. Before, regarding the pension proposal in respect of Narayan Chandra Bora, retired work charge section assistant. Hence, the undersigned requested you to kindly regularize the service of the Narayan Chandra Bora work charge section assistant for onward submission of the government of pension proposal is the interdepartmental communication was going on to regularize the service of the petitioner. But on the date of the superannuation, when the petitioner submitted his pension, then only the petitioner came to know lordship that his service has not been regularized.
Where is that order you are challenging?
Lordship, yes. Please, piece number 68, lordship. 18/5/2020.
68.
68, yes, lordship. I know. One return here with the pension proposal along with the supporting particulars in respect of the above mentioned required employee. As the service was not regularized, the work charge person is not entitled to get any pension. Neither pension will benefit of the petition. 30 years from the service role.
Lord, I have only have a look at page 72, my lord. Page 72, my lord. They have the vendor's case have been come, my lord, which restrict the regularization of work charge and ad hoc employees, my lord. So, my lord, the regulation could not be done at that time, my lord. It's clearly written, my lord. Page 72, page para 8, my lord.
72.
Yes, ma'am.
Now this appointment at page number 15, is it against a sanction post?
Not it is temporary post. Clearly written, my lord. The post is purely temporary and the
Oh, he's temporary, okay, post is purely temporary.
Yes.
Till 2022 when I was retired, lordship. 31/12/2020.
He continued service 21/5/1991 to 24/9/91. Thereafter, his service was terminated, my lord. Again, he was appointed as per order of this honorable court, my lord, on 27/7/1992.
Where is that order?
Lordship, page number 23. pursuant to the order of this honorable court, the petitioner was again appointed.
Again in 93.
Yes, Lord, 27/7/1999.
And then from there you continued.
Yes, Lord. The honorable court has passed that to regularize the service to prepare a scheme, Lordship. After
Where it
that,
is time partner.
there is an order of this court.
Where is that order?
The honorable court passed with December 21. Prepare a scheme and to regularize the service of the petitioner.
That was not done. There was no. You did not pursue the matter also.
Yes.
It's the communication, interdepartment communication.
Now, on what basis are you making the claim? That's what we are asking you. What is the claim, basis of the claim?
Passed by this honorable court, the petitioner is on the service, rendering the service.
That order was passed so many years ago. Why should we order that in 26? What for? It was passed in 93. What were you doing since 93?
Petitioner from the service, petitioner came to know only in the year 2020, Lordship. Then was not ever in service, or because the departmental communication is going on the petitioner.
This is the appointment is just clearly determined as temporary.
You did not read the brief. You have not read the brief. For the sake of your client, we are deferring it only to enable you to read the brief and address the court. Come back on Tuesday with the supporting judgments. It is a duty towards your client, not even to the court. We are giving it away. Read the brief, come and address. All right? On 16th, release this matter on 16th. Enabling the counsel to the petitioner address the court on the issues involved in the matter. Ms. Neogi for
Number 1.
respondent 1, Mr. Sukia for Karbi Anglong Autonomous Council, Mr. Chakraborty for respondent 4, MS appearing for architecture. Yes.
It is. First of all, inquiry has been conducted and I have received the inquiry report.
What has happened?
Lordship, it has been found that the file has been given to the then Deputy Registrar of Cooperative Society and she has not returned it back.
Then what steps are you taking?
Now, Lordship, apart from that, 2 FIRs has been lodged before the Silsar Sadar Police Station, Your Lordship. That regard, Your Lordship, on the last occasion, the government was asked to get the status report of those cases.
Then
File affidavit, madam. Yeah.
bring it on record.
Yes.
Mr. G. Bordeloy, counsel appearing for the petitioner for the cooperation department submits that the inquiry has been completed. He has been furnished with the inquiry report. He submits that he would like to file an affidavit to bring it on record. Brings for 3 weeks' time. Mr. P. Sinha appears for the petitioner. Is also given liberty to file the affidavit as may be filed by this department. Released after 3 weeks.
Right.
I can say.
Lordship, may the matter be passed for the time being. My seniors in another court.
For appointment,
Lordship.
time being.
So lordship, then mechanical difficulties.
All the matters are after some time, then let us know when the councils are free, we'll take it up. We'll have a sitting according to that. You're praying for time being. Time being. Yes.
Your Lordship, I'm for the respondent.
What do you say? Did you file any response? Objections?
Your Lordship, my senior instructed me that in this matter is going on lower court as well.
Huh?
My senior is here as well, but she's in another court at the moment.
Huh.
So,
What is your instruction?
Your Lordship, if you can kindly give me some time, I'll.
Right.
My billing is already completed, madam. There is enhancement of the grade payment inspection. This one before Lordship is the stenographer.
RD? Petitioners are?
Stenographer, ma'am.
Huh?
Stenographer.
Stenographer.
Yes, sir. The case is that they are at present, my lord, receiving the grade fee of 7,500. 7,500. Yeah, but the respondent authorities have given notice on Annexure 6. Married, my lord, in Assam Service Pension Pay Rules 2017. Notification Satra dated 17/3/2017. The published the extraordinary issue of Assam Gazette following correction shall be made, my. The secretary in a pay schedule under the Secretary Administration Department below supplying certain stenographer following agency entities against the post of special officer certain SAS column 1 to 5 page 6 shall be read as senior special officer stenography against the post of stenographer grade 3 in the column 5 page such. Grade 3 stenographer, the 8,500, 8,700. That is the case, man. But at present they are receiving 7,400. They are part of retirement, man.
Who's there for the respondent?
That's in the finance department, man.
Finance department.
Yes, man. They virtually accepted the position, man.
Then
They filed it.
where is their what is their stand in the affidavit?
But they are in their affidavit, my lord. Para 4, man. Para 4 in their affidavit. Depend person page 61. Married. After the issuance of the aforesaid notification dated 27, page 61, second paragraph.
Yes.
After issuance of the aforesaid notification dated 27/12/2017, representation I received from the stenographer grade 3 working officer other than the Assam Stenographer Secretariat enhancement of the GP from 7,400 to 8,700 for all the stenographers grade 3 working under the heads of the department, head office of stenographer grade 3 under the Secretary Administration Department as per aforesaid notification 27/12/17.
Secretariat Admission Gazetted Cell Department being administrative department, considering that the recommendation of 7th PPC was made under the heading of Secretariat Administration Department, was requested to examine the initiate the reforms measure first as per recommendation of 7th Assam Pay and Productivity Commission, and thereafter they come to the Finance Department with a concrete proposal for such unified gather and pay parity proposal with necessary change in the existing service rule if found feasible by letter number such and such 24/10/19. Thereafter, also the letter number such and such dated 24/3/21, dated to such and such is the Administration B Department, Personnel B Department, General Administration Secretary, Gazetted Cell Department. We are requested to initiate reforms measure as per recommendation of the 7th APCC and to submit concrete proposal for unified gather and pay parity of the finance PRU department. However, no concrete proposal has been received from GAD, yet the Finance PRU department has advised GAD once again to take action of the recommendation of 7th Assam Pay Productivity Pay Commission, para such and such of 14 is report to review entire cadre of stenographers to initiate reforms and therefore come up with a concrete proposal for such unified cadre and pay parity proposal with necessary changes in the existing service will be feasible by endorsement number N.
Who's for GAD? So no proposal has come from GAD to the finance.
No proposal.
The administrative department is the GAD.
Yes, and GAD is not a party respondent here, my lord. They have only implemented, my lord.
They have implemented.
No, my lord, they have only implemented, my lord, the finance department and the director of financial inspections, Corp.
Why GAD is not there as a parent department?
The employer is not before this honorable court. Employer is not before this honorable court.
In view of the affidavits, in the view of the categorical averments, the GAD is required to give.
We are under the finance, that is their internal matter, my lord.
You are employed under the finance.
Our parents department, finance department.
Finance department.
Finance is our parent.
So finance, they are trying to draw a parity with GAD, my lord. So therefore, the employees in GAD were given a pay hike, my lord, pay revision. Now they are trying to draw a pay parity. That is the issue.
So why are you asking for GAD to submit the proposal?
So GAD submit proposal, my lord, because these are the stenographers, they are not directly under our employment. It is routed through the GAD, my lord. Because GAD is the General Administration Department which deals with, my lord, all the service conditions of stenographer. That has been categorically spelled out in our affidavit. If Lordship may be pleased to come to page 65, my lord, of my affidavit. We have taken a categorical stand, my lord. And there is no recommendation, my lord, from the pay commission regarding, my lord, enhancement of their pay, leading to, my lord, pay parity.
No, but in your affidavit,
my lord,
you have page number 61.
Page number 61, yes, my lord.
You admit that grade pay of stenographer grade 3 was enhanced to 8,700.
Yes, so far as, my lord, those stenographers working in the Secretariat Administration Department. Now, stenographers are working in various departments. Their nature of job, nature of duties, workloads are altogether different. Source of employments are different, my lord. Their promotional aspects are different. Service conditions are different. All these things will have to be looked into. The apex court has settled the proposition of law that, my lord, so far as pay parity is concerned, one has to, my lord, establish an identical, my lord, nature of work. The petitioner in the writ petition, my lord, the petitioner has not been able to establish that they are doing exactly the identical nature of work. The 2019-18 SCC, my lord, it is clear, my lord. I may read, my lord, from the paragraph, my lord, 92.2, my lord. The doctrine of equal pay for equal work.
We'll come to the judgment. First, let us understand what is the where are the petitioners employed? Rendering their services under the same
finance-
establishment.
Director of Financial Inspection.
Huh?
Director of Financial Inspection.
Director of Financial Inspection.
Under the Finance Department.
Where have you stated that paragraph? They are on paragraph 5. Appointed as stenographer, grade 3 under Directorate of Financial Inspector.
Yes,
Now, who represents the directorate?
well, I represent.
Oh.
Now, my lord, they are working in the Director of Financial Inspection. In one department, that is my lord, Secretariat Administration Department, there was a hike in their pay of the stenographer grade 3. They are also appointed stenographer grade 3. Those persons are also appointed as stenographer grade 3. The pay commission, having taken all the pros and cons and examined all the parameters, my lord, permutations and combinations were laid out, my lord, and thereafter, my lord, there was an increase in their, my lord, pay scale, the grade pay. Now, having done so, my lord, these persons, that is the petitioners hearing, are seeking for a similar revision of their grade pay. Now, for that reason, my lord, we have sought for all the details from the Secretariat Administration Department as well as, my lord, the General Administration Department, because the employment is through that department, my lord. It may be so, my lord, that these persons are posted in the Directorate of Financial Inspections, my lord, but the principal, my lord, employer is the Secretariat Administration Department. Therefore, my lord, lordship will kindly see, my lord.
So, but the appointment order is issued by the Director of
Yes, my
Financial Inspection.
Yes.
Well, we have
Page number
issued it.
39.
Yes, we have issued it, my lord. But since there is a nexus, my lord, between that department and the claims laid by the petitioners, my lord, so therefore we have sought for their views. Then
Sought for, if they have not given, you have to find a way to deal with it. You can't take over with it to say that the views have not come, therefore will not address their issues.
Then their case has to be placed before the next finance commission.
No,
which is
why
already in place.
finance?
So
Where is the recommendation of finance commission?
there is no
Regard-
recommendation. Therefore, lordship, yes, therefore, lordship will kindly see, my lord, page 74. Page 74 of my affidavit, my lord. Annexure D. This is the decision of the government, of the finance department. If I may slowly read it, my lord. Page 74.
Yes.
General Administration Department, your endorsement dated 17/9/2024. Finance PRU Department observed that the 7th Assam Pay and Productivity Pay Commission, white para so and so of his report under the heading of Secretariat Administration Department had made the following recommendations on grade pay of stenographers. The entire cadre of stenographers should be reviewed and the posts available in the district should be included in the cadre. The incumbents of the posts in the district should be allowed promotions in the unified cadre without changing their postings in a particular place. This can be achieved by upgrading the post held by such stenographers temporarily for personal benefit. At every level, there should be a competence test after which promotion should be effected. The grade pay of different categories of stenographers should be as follows. So these are the recommendations. Lordship will kindly see the table, my lord. That's serial number 2. Grade 3, stenographer, rupees 3,300. Corresponding revised pay, lordship will find at 8,700. This is what has been sought for by the petitioners hearing. If lordship turns to the next page, it appears from the above recommendation that the grade pay of the entire cadre of stenographers across all districts should be 3,300. However, prior to that, the entire cadre of stenographers should be reviewed and upgraded into a unified cadre. The posts available in the district should be included in the cadre. As such, Secretariat Administration Department, being the administrative department and considering that the recommendation of the 7th Assam Pay and Productivity Commission was made under the heading Secretariat Administration Department, was requested to initiate reforms measures first as per recommendations of the Pay Commission and thereafter to come up to the Finance Department with a concrete proposal for the unified cadre and pay parity proposal
with the existing service rules. Thereafter also had letters dated 24/3/21 to 11/21. General Administration Department and General Administration Gazetted Cell Department were requested to initiate reform measures as per recommendations of the 7th Pay Commission and to submit a concrete proposal for unified cadre and pay parity to Finance PRE Department. However, till now, no concrete proposal has been received from GAD or Personnel Department. Therefore, Finance PRE Department has issued yet another reminder dated 10/9/24 for submission of concrete proposal at the earliest. The proposal is awaited. In view of above, General Administration Department is advised once again take action on the recommendation of 7th Assam Pay and Productivity Pay Commission and review the entire cadre of stenographers and initiate reforms and thereafter come up with concrete proposal for such unified cadre and pay parity proposal with necessary changes in the existing rules.
Where is the report of the Pay and Productivity Commission?
Yes, that lordship will find that it is a part of the writ petition.
Annexure 5 page 45.
Yes. And precisely, lordship will find it, my lord, at page 67. Page 67 of my affidavit, my lord. These are the recommendations. Page 45 of the writ petition are extracts of the ROP rules, my lord. They lay down the pay structure, but the recommendations per se, lordship will find that, my lord, page 67 of my affidavit. Annexure A. So the administrative department for, my lord, stenographers is the General Administration Department, from whom, my lord, they are selected and they are recruited. They may be recruited to various departments, my lord, but the concerned administrative department at the hierarchy of the pyramid, my lord, it is the General Administration.
So why are they asking for 8,700?
Because, my lord, stenographers working in Secretariat Administration Department were recommended for a revision of grade pay by the Pay Commission at rupees 8,700.
So where is that recommendation?
Yes, that lordship will find at page 67.
67 only talks about 3,300.
No, my lord, that was revised. That has been revised to 8,700. Therefore, lordship will read page 67 with page 69, my lord. Page 69. Page 69. So, there may be the post of stenographers grade 3 in various departments. Their nature of work, their workload, their minor recruitment, educational qualifications, everything may be defined, my lord. So there has to be a wholesome identity between two groups of persons if they are claiming pay parity. This is what, my lord, the apex courts laid down. And the petitioner in the writ petition has not been able to establish that there is a wholesome identity with the nature of work performed by the petitioners in the finance department in the capacity of stenographers grade 3, which those, my lord, of the stenographers grade 3 doing their job, my lord, in the Secretariat Administration Department.
And what is their parent department?
Parent department, my lord, is the General Administration Department. That is the administrative department which holds, my lord, the selection process. General Administration Department is the administrative department, and Secretariat Administration Department is one of such department where the stenographers grade 3 employees were given a minor pay hike and a grade pay was increased. So they will have to establish that I am doing the exactly identical work. My educational qualifications, everything is identical. Without there being materials on record, my lord, it will be difficult, my lord.
Where is the recommendation of the Pay Commission with regard to Secretariat Administration?
Yes, that lordship will
Page
find.
67.
Yes, my lord, page 67. Page 67. Down below, lordship will find para 1.29, my lord.
1.29.
Yes.
But this talks about the entire grade of stenographers.
The entire grade of stenographers, my lord, so far as they are doing their job, my lord, Pan Assam.
Hmm.
Now, the recommendation was that, my lord.
No, the recommendation is there.
Yes.
Unless the authority says that they are not doing the work and not entitled to recommendation is a different issue.
So therefore, the petitioners will have to lay materials before this honorable court. You will have to lay materials. And therefore, my lord, the general administration, including the general administration department, assumes significance because that is the administration department which has conducted, my lord, the recruitment.
Yes.
Yes, my lord, in the initial period, my lord, they have duly recommended, my lord. Duly interviewed and duly appointed, my lord. And they have the grade three, my
No,
lord.
you are in grade 3.
Yes, my lord.
Your parent department appears to be, as per the submission of the State Council Finance Department, is the General Administration Department. They are not arrayed as a party.
In fact, my lord, we are working under the finance department and so it may meet party, my lord. That appointment letter issued by their department, my lord.
Because
Not by the general administration department.
You come to page number 67. This appears to be a recommendation in favor of the entire grade of stenographer.
Yes, including me, then, my lord.
Now, who is to implement this?
the general administration department.
Your parent department through whom you have been selected. Who has undertaken the selection process? Through which department did you enter into service?
The finance department.
Where you are appointed.
Yes, my lord.
But how were you selected? What is the process?
The petition is silent.
Don't know.
Therefore, lordship has seen, my lord, the last 2 pages of my affidavit, my
Then
lord.
what do you want to do? To whom is the direction required to be issued?
Finance department.
Finance department is not the parent department
So
to
I am
examine your
working
claim.
under Finance department, my lord. I am working under finance department.
You are-
And my appointment letter issued by the director of inspection, my lord. So I am by made party finance department and director. The carrier, my lord, there is no spell on this point, my lord.
Annexure G, page 74 of my affidavit is explicitly clear, my lord. What was the necessity on the part of the finance department and general administration department
Annexure
to
A
move files, my lord, and to make deliberations? What was the necessity, my lord?
Document page 53 of my petition, my lord, page 8.
Because-
Annexure 8.
In order to redress the claim of the petitioners, my lord, the decision of the general administration department is silent one on, my lord. These are all government, my lord, deliberations.
That is, last month, page 53, my lord.
Here and there, my lord, without establishing the some identity, my lord.
Has the finance department rejected it?
No, my lord, we are awaiting the proposal because we'll have to see the financial implications, my lord. If their grade pay is increased, my lord, to 8,700, we'll have to, it will open floodgates, my lord. There cannot be any universal pay parity, my lord. It depends from job to job. And when comparing, my lord, 2 jobs, and the dispute is raised, my lord, by one of the persons that they are doing, my lord, they are seeking pay parity, then the test is, my lord, to find out whether they are doing both the work and the nature of work performed by both the employees comes under the wholesome identity. Because these might not involve serious financial implications, my lord, and also the service rules. Therefore, time and again, my lord, the finance department has requested the general administration department, if required, my lord, to revisit their service rules.
Where have you stated in your petition that the nature of work is one and the same?
Last page 53, annexure 8, my lord.
Page 53.
That is the communication, my lord. By that, there is a director of financial inspection from my lord. With the references, I said I have to, with reference the above, I like to furnish the additional financial implication of the amount of such and such, or the fourth stenographer or director of financial inspection Assam, per year if grade pay from 7,000 to 7,400 to 8,000, enhanced for stenographer and there is no whisper about my criteria of what's mine.
They have raised the issue before their immediate employer, that is the Director of Financial Implications. And the Director of Financial Inspections, my lord, has made this communication to the government.
Government, my lord, PRU, my lord, finance
That's
department.
it. And after having made this communication, PRU, Finance Department, my lord, has taken up the matter with General Administration Department. This is the chronological chain of events, my lord. But there is not a single averment in the entire petition and to remotely, my lord, suggest that they are doing the exactly, my lord, the similar nature of work. No, nothing, my lord. It is devoid of any such material. All those factors have to be considered, my lord. At the end of the day, my lord, they are to, my lord, receive the benefit of pay parity.
You did not file a rejoinder, you filed.
Yes, he has filed a rejoinder, my lord. But they are also, my lord, no such averment. Petitioners are only banking upon the my lord, office communications, which are part of the record. These are deliberations, my lord. So no concrete decision has been taken by the finance department. We are ready to take that decision, provided, my lord, the General Administration Department come up with a concrete proposal. That is what, my lord, page 74 of my affidavit says. Not that, my lord, somebody comes and seeks pay parity, my lord, we readily give that, my lord, benefit. It will lead to a cascading effect, my lord.
They are all gatekeeper. My lord.
Their
This is the main thing,
engagement,
my lord.
their my lord,
That is the main thing,
appointment
my lord.
is not at all disputed. What is lacking here in, my lord, are the materials which suggest, my lord, that they are doing the identical work. And an administration department is arrayed as a party respondent, my lord, perhaps in my respectful submission, my lord. To aid, my lord, in determination of the issue in hand.
It's not clear from your pleading that your source of appointment. You are appointed under the department, Directorate of Financial Stability. But the manner in how you are appointed, etc., is not clear. There is a specific averment in the affidavit that they have sought for opinion from the Secretariat Secretariat Administration Department or General Administration. Para 4, I think.
Yes, my lord.
Secretariat Administration. They were requested to examine.
And therefore, my lord, page
But there
74
is no proposal received from GAD, page 62. And your reply to that at page 82 is that these are internal communications and you have no role to play.
Yes,
But you have not been able to clearly lay down that the financial directorate of whatever that financial
financially
institution is your parent department. Not clear from your pleading.
I was appointed under this.
You may be appointed.
Yes,
Please
ma'am.
understand the distinction between the post where you are
Yeah.
appointed and the manner in how you are brought into the service. They're two different things. So your parent department would be the department who has taken your services. You may be placed at different sources, at different places. So from the averments made, according to the state, it is the GAD who is the responsible department who has to send the proposal in terms of the recommendation. You have not disputed that specifically. You have also not arrayed the GAD as a party. So the only thing we can do is to direct you to go and represent before the GAD through your proper channel. That's the only way that's the only order we can see in the present form of pleadings. Unless you want to include the GAD.
Yeah, I will take it.
Then why did we spend half an hour listening to you? We wanted to include the GAD. Counsel for the petitioner seeks liberty to include the GAD and therefore submits that he'll take appropriate steps to file necessary applications for implement of the GAD, implement of parties. Mr. R. Borbujari is into the finance department. Released after 4 weeks.
I'm so obliged.
May it please Your Honor? Your Honor,
Yes.
I'm appearing virtually in this matter. I'm
We can
advocate
see
for
that.
Yes, Your Honor. So Your Lordship, actually, item 19 is a writ petition in which a stay is operating in my favor, whereby this honorable court had granted a stay saying that, that there is an advertisement which was actually published by which they were actually filed for they had filed applications for the appointment of the Deputy General Manager Marketing. But I had already set for this examination for the regulation on this post because I was the acting DGM Marketing. So finally, this honorable court by order dated 13/6/2025 had given a stay whereby it was said a respondents may proceed with the recruitment process initiated by respond advertisement notice, but shall not issue any final order of appointment qua the post of DGM Marketing. Now, what this respondent corporation lordship does is that they go and they make an internal appointment of the chief manager marketing to this post, because of which we have moved a contempt petition in this case, which is item number 20. And now, Your Lordship, I am being led by Senior Advocate Diganto Das in this matter. And on the last occasion when the matter was listed, on that day, Sir had mentioned that we would like to file a writ petition because we need to file, because it is a fresh cause of action. They have gone ahead and they have given a new appointment. This appointment letter we are seeking through RTI at the present date. The RTI, we have not got a response, but it is moving. The application is moving. So we just need 4 weeks accommodation in this matter so that we can file all the matters, so that we can list all the matters can be listed before this honorable court so that it can be heard together at one go.
Yes, that's all.
Writ petition we have filed, the affidavit pleadings are complete because a number of factors have been, cause of actions have been merged, madam.
What is the status of the?
On
There
that
appears
matter,
to be an allegation that you violated the hearing order.
on that matter, I don't have any instructions at this moment. Because there is a departmental proceeding going on, madam. He challenges his, he has not been given promotion. He also challenges that in the writ petition.
This writ petition.
In this writ petition. Main issue is that, madam, in the departmental proceeding, madam, there was an allegation that he had taken some bribe. Some audio clips were supplied to us, madam. The charge sheet was issued. Inquiry was initiated, madam. Inquiry officer said that without verification of the voice samples, no finding can be arrived at. So we requested him to submit his voice samples, madam. He has not given it till date. And in the last communication, he said that Since the petition is pending, my lord, subject.
Your filing of any other writ petition has got nothing to do with this. Whether you want to file, you don't want to file is a different issue, but
Your
what
lordship,
you want to do with this petition.
your lordship, actually they are connected because they have.
So how is it connected? You've not even filed it.
Your lordship, because we don't have the official appointment letter. We saw the
That is for you
Facebook
to
post.
decide, but unless you file a petition, how do you say they are connected?
Yes, lordship, I would just seek 4 weeks time because we will get the information in the RTI. This is what we believe. Your
Then they
lordship,
vacate the interim order.
no,
You are
your
enjoying an
lordship,
interim order.
your lordship, with the already they have. I filed a contempt case also because they have circumvented this interim order. Your lordship. Lordship, please, lordship, kindly grant me at least the right after the matter can be taken up right after the vacation. In the meantime, I'll file the writ petition also.
No, you're filing another writ petition or not is a different issue. In so far as your submissions are concerned, you're basically challenging your non-appointment pursuant
Yes,
to a particular advertisement.
Yes, your
According to you, there is an interim order. They were not supposed to appoint somebody, but they violated. You have filed a contempt.
Yes,
Now, whether you file another writ petition challenging whoever was appointed or not, and more particularly when the writ petition is not filed, why should this writ petition be kept pending like that? And particularly when you have enjoyed a stay order.
Lordship, actually, in this matter, Senior Advocate Digonto Das is appearing in this matter but he was not available today. So that is why we were, and also we had to file this writ petition as submitted by Senior Advocate on the last occasion. So if Lordship may grant me just, or maybe 2 weeks is also fine, your Lordship. Maybe before the vacation, because we need this. We have been,
No.
I've been working in this corporation for 17 years.
Whatever you need is up to you.
Yes, your
Whatever
Lordship.
is before us, we need you to address.
Yes, your Lordship.
That's all. The pleadings are done.
Yes, your Lordship.
It appears that perhaps your writ petition itself has become infractuous.
Lordship, there were actually multiple things that had happened to me while there was this after I set for the interview for regularization to this post.
All right, we'll call it up on Tuesday.
Yes, your Lordship. Yes, your Lordship.
Can it have it on Thursday, my lord?
Thursday, all right. Thursday, 18th.
Yes, your Lordship.
List on 18th.
Obliged, your Lordship.
List on 18th.
Yes, your Lordship.
Wednesday is okay, sir.
No, 18th.
18 is fine, your Lordship.
Yes. List on 18th from the request made by the council. Mr. N. Dekar, City Council, listed by Mr. M. Gogoi. Appears for the P. Barwa and appears for the petition. Yes.
I am led by learned advocate general in this matter. Give them legs in another court. Can we just
What is the issue here?
The issue, my lord, selection and appointment, the oil.
What are you challenging? Pleadings are complete.
Pleadings are complete, my lord. My lord, in the meantime, my lord, I would like to, my lord, file an additional affidavit to the selected candidate.
In the meantime,
Who?
The selected, who we are already appointed.
You want to array them as parties?
Yes.
Then additional affidavit will not do. Counsel for petitioner submits that you would like to take steps to file an appropriate IA for hearing, seeking prayers for hearing the selected candidate as party respondents.
Already appointed, subject to outcome of this meeting.
Selected candidates already appointed. Mr. E. Sharma.
my senior's name will be recorded.
It is not here. We are recording your name.
But
Mr. E. Sharma.
He has been engaged in this matter.
He may have been engaged, but you're on live telecast. Don't forget that. Mr. A. Sharma appears for the Oil India, who submits that Mr. D. Sakia, Senior Counsel, appears for the petitioner. You are right in time, Mr. Sakia.
Yes, exactly.
I was here actually for one case. Wow. So he wants to file some
IA.
So we have no objection to that. Otherwise, we would have raised that plea.
The petitioner the bills against senior counsel, pays for the respondent, listed by Mr. E. Sharma. Relist again after 4 weeks. All right, 4 weeks. 4 weeks.
Highly obliged. Obliged.
Happy Villa.
Hmm.
This issue pertains to the DCRG which has not been paid to the petitioner. On the last occasion, Lordship, my learned friend has pointed out certain aspect of the matter, and accordingly, one additional affidavit has been filed in this case. Now, straight away, if I go to the additional affidavit, Lordship, in the additional affidavit, they've taken as P that the petitioner is entitled to an amount of rupees 4,94,520. Can you see page number 60?
Additional affidavit.
Yes.
Yes.
Additional, page number 60.
DCRG gratuity.
Yes.
4,94,000.
4,94,520. Now, before filing of this additional affidavit, Lordship, the concerned authority had filed the affidavit in opposition. In that particular affidavit in opposition, if we, Lordship, when they go to this particular annexure, this is annexure page number 37.
Thirty-seven.
37 and 38. The initial calculation was made. In annexure page number 37, this concerned executive engineer, the order has been passed mentioning that an amount of rupees 7,56,612 only is hereby sanctioned as death cum retirement gratuity to Sikh Sarkar retired watchers of the division who had retired from government service after rendering 29 years, 6 months, 14 days of continuous service as per rule 153 of the Assam Service Pension. So in the next page, Lordship, this calculation is there. Calculation is there. Therefore, as per the Assam Service Pension Rules 1959, the amount of DCRG to be sanctioned is 12 months pay. Pay on such and such, grade pay, and the DA on 31/1/2025. It's such and such. Hence, total amount is 7,56,600.
So according to you, it is 7 lakhs.
Yes, 7,56,000.
According to them, it is 4 lakhs.
4 lakhs. Not me, Lordship. That was this order that has been issued by the executive engineer PWD time. And that was the initial calculation which was made. Subsequently, we had a separate calculation, but that has not been taken into account, and they have come to the conclusion that I am entitled for 7,56,000. So the initial plea of the respondent was with regard to 7,56,000. Now that when the additional affidavit has been filed, in this additional affidavit, they have come up with the plea that as per the rule 153 of the Assam Service Pension Rules 1969, the admissible gratuity is 1 year's pay. Now the definition of pay, they have incorporated the pay and the grade pay. The basic pay is 4,94,520. So this is the calculation they have made. Now, if your Lordship kindly see the provision of the Assam Service Pension Rules, the authorities are relying on this 153(2), the pension and the gratuities. The Assam Service Pension Rules. I'm just.
Now, why the calculation has not been accepted? Calculation of the executive engineer.
No, they have not specified why it has
No,
not
we
been.
have specified, Lordship. There are two one is page 38 and one is page 60. Lordship, I kindly see both the pages, Lordship.
Page 660.
160 and one is 38.
Ah.
If Lordship peruses 38, Lordship,
Ah.
it is a calculation given by the concerned executive engineer that there are three components, Lordship, A, B, C. That DA portion, Lordship. According to the finance department, the DA portion should not be there, should not have been there. And accordingly, minus this DA, the amount, it is 4,94,520. Only that distinction.
So why the DA has been deducted?
Lordship, according to the finance department, Lordship, so far as the calculation of DCRG is concerned,
That DA portion is not, should not have any.
What basis?
Lordship, first case, Lordship will see the definition of pay, Lordship, under FRSR. And second one is, that is Assam Gazette, ROP rules 2017, Lordship.
ROP.
ROP rules 2017.
ROP rules. What is the FR, sir? FR?
Define definition of pay, Lordship, it should be Lordship FR 921 AI. 921. The pay commission is quite clear, Lordship.
So 921.
FR 921.
Is it available in your book?
Have the copy only, Lordship. Then Lordship may peruse the ROP, Lord. It's quite clear.
Page number?
Page 291.
Yes.
Therein, Lordship may kindly see 6, dearness allowance.
6.
Dearness allowance. The existing provisions regarding grant of dearness allowance is in accordance with the policy followed by the government of India shall continue. Lordship, another page is here, annexure J, Lordship. Probably it is not before your law.
Oh. Page number? You have the FR.
My prayer will be, Lordship, grievance of the petitioner is non-payment of discharge. And at that point of time, it was not
So
because
except for the DA, everything else is accepted.
it is accepted. So let him receive this amount, Lordship.
But we want to find out what is 921 because in this book there is no 921. We have 9, 19, 20, then 23.
I have to clarify that point. I have to clarify that point.
It's not there.
It's not there. 921.
Not there.
Start from 923, 24.
You have 9, 19, then 20, then 23, 24. Mr. S.P. Chaudhary, you have any access to that? 921?
Lordship, other than that, Lordship, kindly see the definition of 152 with regard to pay.
Where? 152 where?
Assam Service Pension Rules, Lordship.
Pension rules. Yes.
This particular definition, the temporary government servants, the note is there where it has been mentioned that pay for the purpose of determining the amount of gratuity will mean only basic pay and also the dearness pay, if any, at the time of relinquishing service. So it has been clarified in 150. Entitlement of the petitioner. And in our reply to that additional affidavit, Lordship, we have annexed certain documents where it goes to show in case of similarly situated persons, they have included the dearness alum. The Lordship,
No, first, let him clarify
Yes.
what is 921.
yes,
Mr. S.P. Chaudhary, Learned Counsel, for the petitioner submits that petitioner entitled to pay is DCRG
yes,
as calculated by the executive engineer, which is shown to be 7,566,12. This calculation is reflected in annexure, page
38.
49 of affidavit in opposition filed by the finance department. Page 49, which is a part of annexure A, the affidavit filed by the respondent. Stop. Learned counsel for the petitioner therefore submits that the objection raised by the finance department that he is not entitled to the amount of DNS allowance shown in calculation of the executive engineer without any basis. Mr. Nayak, additional AG appearing for the state, submits that on instructions that as per Office Memorandum 4 November 2016 of the Government of India, the DNS allowance will not be treated as pay within the ambit of FR 9/21. In other words, counsel for the finance department submits that the DNS allowance has to be excluded while calculating pay for arriving at the DNS allowance pay. So, derivative of the FR 21, FR fundamental rules of the state. State financial in the state FR and SR. So, counsel for the finance therefore submits that he would like to complete his instructions in these matters. I think what is referred to is FR of the central government.
FR 21.
Accordingly, they release this matter after 2 weeks.
In the meantime, Lordship, the amount which has not been disputed can it be released?
This will, the respondents, however, will release the amount which is not disputed. Namely, the amount, where is that?
This is page number 16, Lordship.
Amount which is reflected at
4,92,000.
reflected to be 495,520 as reflected in para 3 of the additional affidavit filed by the Treasury Officer. Relist after 2 weeks.
Within a certain period.
Hmm?
Within a certain-
Endeavor should be made to release the amount without further delay within a period of 2 weeks. Mr. Medi for respondent number 4.
Lordship, in this matter, I request some time to file rejoinder.
Just a minute, please. You want some time to file?
Rejoinder.
Mr. P. Chaudhary, learned counsel appearing for the submit said you'd like to file your rejoinder affidavit, MSN board number 8 years. Yahoo, when this matter be listed after 4 weeks.
Interim order to continue.
The interim order, if any, will continue until further orders.
Fix a particular date.
The month
After
of
4
August.
weeks,
In the month of
let him
August.
file, then you fix a date.
Yes, sir. That's better.
July maybe.
July.
No, let him file, then you fix a date. Yes.
This is the lordship. My lord, in this matter, I am being led by senior counsel, Mr. P. Das. My lord, if your lordship remember, on last Tuesday, this matter was listed by this honorable court, my lord. And on 4/6, this matter was substantially heard. That's why your lordship listed as part heard. Now, my lord, since the matter came up today, on the last occasion, senior counsel, Mr. P. Das has made certain submission. Now, my lord, the ONGC wanted to make further clarifications. So the matter was fixed for Tuesday. But since this honorable court was not there, it has came up today. Started
Tuesday means?
last Tuesday, my lord.
Okay.
Your lordship was not sitting, so this matter came up today.
Yes.
I'm led by Mr. Indranil. He's unavailable today, Mother.
Huh?
He's unavailable today, Mother. Taking some accommodation. It can be taken up after the vacation.
Then we release it from partner.
My lord, we have some urgency in this matter.
You can't keep partner matters till after
Yes.
vacation. Why to
On Friday, my lord, it will be taken.
He's not available, Mother.
Then
Or on
Tuesday.
Tuesday, Thursday, my lord, your lordship is already fixed one matter.
All right, Thursday, 18. 18.
One can
He's
be on
not here, my
Wednesday.
lord. He's not here for the entire week.
That's hardly around. It was understood that the matter should be heard. It was kept part heard. What is this? You'll have to make alternative arrangements.
It's a week thereafter, my lord.
Week thereafter is the last week. There can't be a hearing. Yes. 18th. Let it be on 18 or we release it from part head. Let it come whenever you want.
Your lordship has heard it, that's why, my lord. The promotion has been installed, my lord. That is the problem.
He has been granted the promotion, my lord, with effect from 1st January 2026.
But we are
It's
claiming
already,
from
it's
2025.
the only thing that remains is whether or not he is entitled to the promotion with retrospective effect from 1st January 2025. He's
When
already
are you
been promoted.
retiring?
No, my lord.
You're not retiring now. Then where is the urgency?
But they are giving effect to an office memorandum retrospective. That is why your
That's
lordship,
right. So you are now promoted.
from 2026.
Are you promoted to the post that you are claiming promotion with retrospective date?
No, my lord. From the present date, they have promoted.
They are promoted, but you've got the promotion.
Yes.
Your claim is now retrospective.
Yes. Because my promotion was due on 1/1/2025.
On the submissions of the council for the respondent, release this matter month of July on a date to be fixed by the registry, matter not to be treated as part of it.
My lord, can a date be fixed? On 20. On 21st, my lord. 21st of July, it's a Tuesday.
You take your dates 23rd or 30?
23rd, my lord.
23rd. 23rd.
I'm big.
The petitioner here
the person with benchmark disability, man, is visually impaired. And my lord, as things happened, my lord, he had applied for a post and he was selected, and thereafter he was sent for a medical examination in which he has been disqualified by a non-speaking order. That is the case, my lord. Otherwise, my lord, he has already been certified as a, my lord, person with disability. Those certificates are annexed 1, 2, and 3. Not 1, 2, 3, and 4, my lord. Page 25, 26, and 27. And 20 of the your lordship will kindly see the impure order at page 57.
Seven.
Yes, ma'am. Annex of 14. There is a table given. Serial number, then the position in APS is the merit list, then roll number, then name of the candidate. At the bottom is mentioned the name of the petitioner for unprotein board. And the benchmark disability is minor visual impairment. And the medical board's comments is clinical and investigation findings do not correlate with certified.
You're reading from page number?
Page number 57.
7.
Right.
Serial number?
5.
Hmm.
That is a petitioner, madam. We can.
Okay.
Then the category of benchmark disability with impairment.
Hmm.
Then their remarks is clinical and investigation findings do not correlate with certified.
Hmm.
This I have challenged and I have prayed that madam I be given to appear before a freshly constituted medical. That is the prayer, madam, and such sorts of
Where is the certificate
why
of
not that 20 page 25 onward.
25?
Yes, ma'am. 25, 26, 27, 28 of the request. These are issued by a board, man. Your lordship will kindly note. Page 25. Member medicine, member ENT, member orthopedic, member surgery, member ophthalmology, and district, chairman of the district medical board, come joint director of health services. Marked as 40%, one with 40% disability. Then next one is the disability certificate. What should we kindly see?
Yes.
Diagnosis in this case is left eye. That is perception of light, plus right eye normal, posteriorly blind. He has 40%.
We'll come back after. Yes, please. Where is that certificate issue? Page number?
Page 25 onward. 25, 26, 27. And 25 shows that the certificates were issued after examination by a board. With the joint director of health services of the particular district as the chairman. The district medical board. Then, my lord, the page 26. So we kindly see A, B, C. A is the case of low vision. Diagnosis in this case is left eye, L plus right eye normal, posteriorly blind. Posteriorly blind, they are unable to read without spectacles. Man. C, he has 40%. In figure 40%. Permanent disability in relation to his left eye as per the guidelines. So and so, so and so, so and so. Defined by government of India, right? Then my the doctor's diagnosis sheet. Page 27. Disability percentage is given as 40. Disability condition, then it also says not likely to improve. Nature of disability is permanent. Have you watching at page 27. Signed by the Joint Director of Health Services, Bulagat, Assam. Then the card given to them, it's called Unique Disability ID.
20,
Unique Disability ID,
28.
page 28. So, Lordship will see it marks the number, the ID number, and the disability type, and the percentage of disability.
Now, where is the rejection?
Rejection is there, madam, at page 57. It is absolutely non-speaking, madam. It says, at the bottom.
So there was some clinical examination.
They constitute a board for the purpose of selecting candidate for the particular post. After the selected candidates are subjected. But
Now, what is
my submission is that once I have been given that certificate, is it necessary to?
that certificate?
Yes,
if you come to page number 25,
why not?
what exactly is the finding here? In the left eye, what?
Your Lordship will kindly
Partial
see-
loss eye.
Yes, ma'am.
Left eye, partial loss. Right eye, normal.
I know.
So you are partially blind. 40%.
My lord, your Lordship will kindly see that is dated back to 28/12/10.
Huh.
The recent certificates are at page 26, 27, and 28. Dated 7/9/21.
Is there a possibility that your, I mean, your
improvement?
ah,
No, my lord. In fact, on page 27, the particular doctor, the Joint Director of Health Services, that board, my lord, they have marked not likely to improve.
where are the findings to this page number 57? What are the supporting documents or orders or clinical findings? Is there anything there?
They have filed an affidavit. So will kindly come to page 100 of the affidavit filed by page 100, madam. Page 100. This is an office order passed by the principal cum chief superintendent, the MCH.
This is the board, medical board.
Yes, my lord, and there, my lord, at serial 7, the lordship will note Dr. Abdul Latif, Associate Professor of Ophthalmology, GMCNH. That particular faculty member was deputed
You were examined on 18th.
18th and 20th.
18th and 20th.
So I have taken the ground that on 20th there was nobody appointed.
So why were you examined on 2 days?
My lord,
Any particular reason?
it is for them to explain. But on 20th, no officer was deputed. So we are not aware, my lord, who had examined me. Now, clinical finding, my lord, so far they have given an annexure page 18, echo 1 and 102.
102, 101 and 102. 102 page, my lord, if I can read correctly, my lord. At the bottom says clinical and investigation findings does not, as your lordship, does not correlate with some data, my lord. Certified data. Clinical and investigation findings does not correlate with certified data. And this is dated 20th of December. On which date no board was there.
All right then. So your case is number one, that subsequent medical finding is not necessary in view of the declared
Yeah, also, my lord,
disability.
I myself had examined myself, my lord, after their test again, which I annexed to my writ petition. Yes, my lord. The last page, my lord, page 61.
61.
Yes, my lord.
Yes.
And there, my lord, parenthesis, the lordship will kindly see towards the bottom, my lord. Clinical findings on the left for inference. Then it is written visually handicapped more than 50% for all practical purposes. Color vision partially deficient, red green deficiency, and one-eyed person. He has been described as a one-eyed person.
What is the stand of the respondent?
Respondents rely on, my lord, but if your lordship kindly come to page 87, my lord. The affidavit filed by respondent number 6. My lord, yes, in reply, their averments at page 63. Sorry. Page 63 of the affidavit by respondent number 6.
Yes.
That if I, my lord, may I read out?
Yes.
Answering the opponent begs to state that a reservation of 4% for posts and services of state government is accorded to persons with benchmark disability as per the instruction issued by Personnel Department by OM dated 7/1/2019. In line with provisions made in the Right of Persons with Disabilities Act 2016 and the Right of Persons with Disabilities 2017. That it may be pertinent to mention here that Section 5 of the OM clearly mentions that a person who wants to avail the benefit of reservation will have submit a certificate of disability issued by a competent authority. Such certificate, in the event of selection of such person for any post, will be subject to such re-verification as may be decided, which I say is not the correct proposition, because, my lord, that is a statute and this notification can get over that. That I replied in my page 87, my lord, in my reply, para 3. Page 87. As you know, sir. Extended the permanent disability certificate of 40% dated 79/21 issued by the company authority as per the guidelines for the purpose of assessing the extent of specified disability in a person issued under Right to Persons with Disabilities Act 2016. Such a certificate issued under Section 2R of Right to Persons with Disabilities Act being statutory in nature cannot be disregarded or overridden by official response on the basis of purported provisions contained in the office memorandum dated 7/1/2019. The action of the official response discipline the deponent in exercise of purported powers conferred under Section 5 of the same OM is not sustainable under the law and facts and circumstances of the case, and such honorable could be interfered with the said action of the respondents. My lord, in the act, my lord, that section I have just referred to.
No, what is the basis of your challenge? What are you challenging?
My
You are
lord,
challenging the second examination.
No, I am challenging only one examination by day. They carried out on 2 days, my lord. One was authorized. The second day was not authorized, my lord. No one was deputed, my lord. There is no order. They have not produced. That is a different thing, man. Now, my lord, the result is that they disqualified me, which I challenge. On the basis of the further test I have done with a private doctor, which gives, he's a retired doctor of the GMCH, my lord. Anyway, my lord, and I pray that I be subjected to a freshly considered. But
Yes.
my, that is all, and that,
You
those
do it.
orders have been passed, my.
In fact, Lordship has already passed one similar order.
Do it.
I have no objection.
That is all.
Where is that order?
In fact, the authority of the, of the state lordship to verify the disability is not under challenge. He is only praying for reconstitution of the medical board in re-examination. That is his prayer.
So your objection essentially is that the test by which you are found to be what is the term used? Not correlated with clinical findings.
Yes, madam.
According to you, it
That
is
is-
not clear whether it is the finding of 16th or 20th or both.
And that is one theme of the argument, my lord. I say that, my lord, I have been given certificate. I am already certified, and that is in exercise of the power under the statute, man, by the district board.
Mr. Goswami,
I-
please understand one
Yes,
thing.
ma'am.
Is it your case that certificate having been given, no further test is required?
That is one. Number
Then
two
you
is
have to challenge,
Right.
then you have to challenge these particular steps taken. You have
Right.
submitted to the, you have yourself submitted to the medical test,
Madam,
right?
madam.
Now, not having been selected, you are, or rejected, you are now coming in challenging it.
Madam.
Had it been a case that at the threshold, when you are called upon to appear, challenge that, no, you are not required to appear in view of this valid disability ID card.
My lord, the second leap of argument is also there that they had carried out this on a day by an unknown doctor,
So-
my lord, not doctor. So that is also there.
So effectively,
Yes.
what you are aggrieved is by the finding, and
Yes, ma'am.
you are agreeable to a
Yes,
reassessment.
reassessment. That is
Reassessment by the said medical board,
Madam.
comprising of at least one ophthalmologist.
Not the same medical board, my lord. Your lordship, a freshly constituted, your lordship, will be
Freshly
the same doctors
constituted.
will not go.
Freshly
Yes,
constituted
yes,
with
yes.
the ophthalmologist.
Madam.
All right.
Otherwise, my lord, they
Lordship,
will.
in fact, in this judgment, Lordship has already specified the manner in which the board is to be constituted. Paragraph 7.
Principal come chief superintendent, this is GMCH.
Yes.
GMC.
GMCH to constitute specialist who be personally present. All right.
That
We'll
is-
direct the principal to be personally present in the committee.
Proper investigation be carried out, my lord, that is all. I make.
Basically, it's para 7 and 8 Lordship. Here, Lordship is directed to, bring the records of the concerned joint director, Lordship. And
So we'll say that if required, you may call for the records
yes,
of that state wherever your examination was done. Disposing it of. And it will be in a time bound manner.
Yes, it has to be done. Because
Say
if
within
one post is being drafted, my lord.
3 weeks from the
just
date of.
online somewhere, Lordship, he will cooperate with the authority, Lordship, in the affidavit filed by the health department, Lordship.
No,
One-
he will submit a copy of the certified copy of this order.
No, in the
Pursuant to
earlier
which-
earlier round, Lordship, there is a specific line in the affidavit, Lordship. He was not cooperating with the, the board, Lordship.
No, this order will be given. He has to appear before the principal
Yes.
along with a certified copy and with the addresses where you are required to be intimated, and they will intimate you appear. Right? That much of trust we have to leave on the state authorities.
Disposed. Okay.
Disposed. No money. The
Of that-
order it has to-
Yes.
Make your lordship, no?
We were informed you were before some other court.
Lord, I was in some other court, Lord.
It doesn't appear to be another court.
My lord,
All right.
My
Yes.
learned senior friend Azulek submitted his written argument. Today I am submitting.
But at least tell us what is there in the written argument so that we understand what is there.
The notice was issued,
Uh,
petitioner asking for submit their reply. They have challenged the notice, the ground that no evasion is there. No suppression of act is there. On that ground, notice is challenged.
Dr. Saraf, can you just quickly
my lord,
refresh
My
our
lord.
memories?
Lord, the work order was issued to the petitioner, which you will also find in page 67.
Yes.
And thereafter, the work was completed on 21/10/2020, and you'll also find page 68.
Yes.
Thereafter, my lord, there was a price variation of rupees 32 crores, and that was received. Payment was received on 20/10/2022. Page below the variation, at that part we'll also find page 69. The receipt,
Yes.
receipt of the amount at the bottom of the circle, you'll also find 20/10/2022.
Yes.
Now the petitioner submitted his income tax return for 2023-24, and at page 83, the return is there. And the relevant part you'll also find page 85.
GST payable.
My lord, this amount was shown in the return of the income tax in 2023-24, my lord. Because the amount was received on 2010-2020, my lord. So in 2023-24, this was shown the payable. Now, my lord, this amount which was received by the petitioner was on a turnover of 23 crore that you also find in page 85. Turnover is also shown, my lord. This is after the TDS, my lord. As you also have the TDS which is deducted by the department, that has to be submitted on the portal. And you also may find page 99. Page 99, my lord. You'll also find in the second column total taxable value. Has you also got in,
99.
page 99, my lord.
Yeah.
In the second part, my lord, this was on 12/12/2020, my lord. And in the bottom, we also have TDS credit received. Total taxable value. As you also got in, my lord, second column.
Yes. Yes.
35 crores, 36 crores something. Then you'll also find the central GST. This is the TDS deducted. As GST, this is the TDS deducted, my lord. And the petitioner, the SSC has to either accept it or reject it. You'll also find on the right hand side equivalent accepted.
Yes.
So this is from the department, my lord. This has to be uploaded by the department. Now the department has uploaded that this amount was received, and this was the TDS, SGST and CGST, and the same was uploaded on the Milord portal, and the same was accepted. Now, Milord, the petitioner, thereafter a search was made, and after the search was made, Milord, the so-called notice was issued, and the so-called notice you'll also find at page 132. And the relevant part at page 146, Milord.
Sorry,
Page 146, the relevant part, Milord.
146.
My lord. Seven point two. Married, Milord. 7.2. Page 146, Milord. After the explanation.
Yes.
In this context, it is submitted that the noticee is a government contractor, and maintenance of the books of account, filing of the GSTR and income tax return, etc., are basic responsibility of the noticee. From their submission, it is clear that the noticee is well aware with the legal provisions of the taxation matters, including the provisions relating to the applicability of GST, applicability of circular, and notification issued from time to time, and payment of GST is levied on the supply of goods and services and the provisions of CGST Act 2017 and the rules made thereunder, as well as similar provisions in the Assam GST Act 2017 and also IGST Act 2017, includes rules made thereunder, where a system of self-assessment and self-disclosure through periodic return is prescribed. In other words, it is a legal responsibility of the noticee to obtain registration, assess and discharge the tax liability as per the provisions of the Act and declare the same through the prescribed periodical return. It has been noticed that during the scrutiny of the returns documents submitted by the noticee in course of the investigation, that the noticee has failed to self-assess and pay the GST liability correctly for the period from July 2017 to 2023, thereby suppressing GST liability amounting to rupees so and so, resulting in evasion of GST in contravention of the provisions of so and so. So, Milord, the basic reason for issuance of the notice under section 74(1) is that the assessee has failed to self-assess and pay the GST liability correctly for the period from so and so, and thereby resulting in the evasion of the tax in contravention of provisions of so and so. Now, as your lordship is aware, my lordship has dealt with a similar matter while dealing with the Finance Act of 1994, which was section 73, my lord. If your lordship looks into the judgment in Nirmal Kumar Sarma, I have given you a copy, my lord.
Yes.
Lordship may kindly see para 56, my lord. Because in the compilation, my lord, all the judgments of Supreme Court which has been referred to, your lordship has referred to all the judgments in this judgment, my lord. 56 para, page number 56.
Yes.
So this was in context of 73 of the Finance Act, which is parameter, my lord. Coming to the fact and the present proceedings from the recital of the impugned order in original, it is seen that the respondent authority has held that the petitioner assessee did not willfully get service tax registration nor filed the periodical ST3 returns, and therefore did not discharge their service tax liability to the government exchequer with malafide intention to evade payment of tax. The assessing authority therefore concluded that in the absence of the periodical ST3 returns being not filed by the petitioner, or the fact that the petitioner did not get service tax registration, there was deliberate suppression of the material facts from the department with the intent to evade the payment of service tax, And as a consequence, therefore, thereof, the provisions of Section 73 for extension of the limitation of the 5 years was involved the demand and recovery of the service tax sought paid. Such conclusions as have been discussed have contained to the facts which are evident from the pleadings. In any view of the matter, for invocation of the provision section 73 of the for extension of the period of limitation, it must necessarily be a case of which falls under any of all the conditions specified in proviso to section 73(1) of the 73(1), it will be a finance act. From a plain reading of the impugned order in original and the relevant portions which have been extracted around, it is evident that there is no finding of the judicial authority that any case of prisoner can be considered to be a case which falls under any of the conditions specified in the provision section 73(1). Under such circumstances, the impugned order in original appears to the court to have been exemption of jurisdiction by the revenue authorities, which was not otherwise vested in the state authority. For the revenue authority to invoke the powers in the section 73(1), there must be finding and a conclusion arrived based on the facts of case that the prisoner SSC has willfully and deliberately resorted to fraud, collusion, misstatement, suppression of material facts of contribution of the provisions of the Act with the intent to evade the payment of service tax. Therefore, for invocation of the powers of the section 73(1), there must be conclusive finding arrived at by the revenue authorities that the prisoner SSC has resorted to any of all the above acts and omission with the sole intention to evade the payment of service tax. Such a finding is not discernible from the impugned order in original passed by the revenue authority. Therefore, the assumption of jurisdiction of the revenue authority under section 73(1) has to be concluded to be the jurisdiction arrived by the revenue authority, not vested on it a statute. Such assumption of jurisdiction, therefore, being contrary to provisions of the statute, in itself the same is culpable and therefore is liable to be held to be unauthorized. The lordship may thereafter skip over and may come to my lord. Paragraph 79. At page 72, my lord. And you also got it, my lord. Page 72, paragraph 79.
Yes.
Although ordinarily it is the law initiated by this court as well as by the appellate court that elected BCC ought to avail of the statutory remedies prescribed under the statute, there is no quarrel in the principle of law. The GST is a complete code in itself, providing for filing of the returns, assessment, recovery, as well as the appeals before the appropriate tribunal. The facts involved in the present proceeding are however peculiar in the sense that the so-called notice and the consequential confirmation of the demand by the impugned order in original was the proceeding initiated by the respondent authority after invoking the extended period limitation under section 73(1). Therefore, in an ordinary course of the proceeding seeking recovery of tax demanded, the normal course would be to avail the statutory remedies. However, before the authority to invoke their jurisdiction under section 73(1), it is mandate of the statute that the authority must come to a specific conclusion that the jurisdiction conferred on the revenue authority under section 73(1) can be invoked in the facts and circumstances of the present case. As have been elaborately discussed in the preceding paragraph, that the invocation of jurisdiction under section 73(1), the respondent authority must come to a conclusion that the invocation of the powers under section 73(1) is necessary as the petitioner case falls under any of the conditions in the section 73(1) of this Act. However, from the recital of the order impugned, it is seen that the primary reason for invoking the jurisdiction 73(1) is non-furnishing of the required documents and petitioner SSC to be full satisfaction of the respondent authorities. This thus mere non-furnishing of the documents or information in itself cannot be considered to have give rise to the situation under any of the or all of the 5 conditions of the section 73(1) in order to levy service tax by extending the limitation by the revenue authorities who have invoked the powers under section 73(1). Under such circumstances, ordinary revenue authorities would not have issued the impugned notice in the demand followed by the order in original, as it would be hit by the limitation. It is only by invocation of section 73(1) of the GST Act the revenue authority have assumed powers for issuance of the so-called notice and the consequential confirmation of the impugned order in original by extension of the limitation. Therefore, the parameters prescribed in the section 73(1) are to be scrupulously and diligently followed by the revenue authorities. It does not depend on the exit dixit of the revenue authorities. They must evidently arrive at a specific conclusion that non-furnishing of the documents leading to the non-payment of GST is a deliberate and willful attempt to the SSC to evade the payment of taxes. The revenue authority were within their rights to issue appropriate actions and carry out proceedings within the ordinary period of limitation prescribed if it was the conclusion on the examination of the material before them that there was any shortfall of the payment of GST and the same was required to be recovered. However, this process for demand and recovery was not initiated within the period of limitation ordinarily prescribed under the Provisions Act. Therefore, the Revenue Authority invoked the Provisions Section 73(1) to issue the demand cum so-called notice and consequently impugn order in original the demand and imposition of the penalty and interest. It is the view of this court that the demand and recovery of tax as ordinarily prescribed in the provisions of the Act requires careful consideration of the facts and circumstances and satisfaction of all the parameters upon which the demand and recovery under the extended period limitation section 73(1) being an exception in the general rule requires a higher degree of responsibility and diligence on the part of the revenue authorities before they can proceed by invoking the powers in Section 1. It is to strike law that the greater the power prescribed under the statute, greater will be the responsibility upon the authorities on whom it has been bestowed to ensure that no deflection of the provisions of the Act's rules are made and no injustice is caused to the SSC being the process of demand recovery. This court, while examining the facts and circumstances in minute details and the exposition of the law laid down by the various courts, including the court as well as the apex court and the country, has held that the revenue authority to invoke the powers in the Section 71, there must be conclusive finding by the revenue authorities that the SSC under the facts and circumstances willfully and deliberately evaded the neglected to pay the GST. This conclusion by the revenue authority is not apparent and discernible from the plain reading of the impugned order in original. It is not the case that the petitioner SSC never responded to the notice. It is not a case that the documents which were called for required or submitted were not furnished. The ST3 returns filed by the petitioner SSC were available in the records of the revenue authorities and which would give a complete picture of the services rendered by the petitioner SSC and to whether such services come within the purview of the ambit of the service tax or are excluded were any circular notification issue. However, there is no finding on the revenue authorities as to why this aspect was not examined. There is no conclusion on the revenue authorities this aspect is so and so. Therefore, under circumstances, the invocation of the powers under Section 73(1) has been held by the court to be invalid and contrary to the prescription mandate to law. This being the position, it is a clear case of assumption of the jurisdiction by the revenue authorities, where the statute did not confer such a jurisdiction or default. The writ court and thereafter below, the lordship has set aside costs. Now, in this case, below, the lordship find that the department itself was aware and TDS was deducted at source and they filed the return and the petitioner has accepted the same. And thereby, my lord, to say, my lord, that the petitioner has suppressed or, my lord, committed fraud for the purpose of evasion of the tax, suppression of tax, there is no question of the suppression of tax. And you lordship is aware in the judgment, lordship has dealt with the various judgments where he says, my lord, mere non-payment of the tax does not amount to suppression, fraud, or, my lord, willful misstatement of the material facts to evade the payment of tax. In the written submission, you will also find lordship may kindly see page 29. The last paragraph below.
Yes.
The petitioner has all along been disclosing the amount received in the balance sheet ITR filing as well as in the annual return filed for GST, as the materials were always disclosed in the relevant authorities, including GST authorities, by the petitioner. The petitioner, as per Rule 66 of the so-and-so rules, affirmed and declared before the GST authorities that the amount has been received by them in its declaration dated so and so, and thereby there was no due intimation. There was no intimation of the same. There was due intimation to the same department. It is submitted that to confer jurisdiction section 74(1) of the Act, either of the three conditions stipulated therein have to be fully satisfied. The three conditions are that the professor has to come to a conclusion that the tax has not been paid by reason of fraud, or there has been will statement or suppression of the material facts to evade the tax. Admittedly, there has been no fraud. Thus, the only question is whether the proper officer has reason to come to conclusion that there has been a willful misstatement or the suppression of facts by the petitioner to evade tax. In other words, whether the assessee, that is, the petitioner, had disclosed all material facts for his assessment. It is submitted that the petitioner had filed the audited balance sheet for the assessment year so and so before the income tax authorities, recording the receipt of the notice, adjustment, and thereafter the petitioner, in the genuine and bona fide belief that the amounts which were received at price adjustment respect to the works for which the assessment was in turn were not taxable under GST, has shown the amount received at the price adjustment as exempted while the filing the GST returns for the financial year 22-23 in December 2022. The income tax return as well as the GST returns are public documents, and when the receipt of the price adjustment money stands reflected in such public documents, it cannot be said that there was any suppression or misstatement on the part of the petitioner so as to invoke Section 74(1) of the CGST Act. It is submitted every detail was maintained by the petitioner in usual course of business, and such suppression or misstatement cannot be held to be present for the respondent authorities to invoke Section 74(1) of the Act. It is explicitly submitted that for an act to qualify misstatement suppression of fact, the act has to be willful, not mere omission, or the words misstatement suppression are qualified by the word willful. Thus, any omission on the part of the assessee, unless it is deliberate, willful attempt to escape the payment of tax, will not amount to misstatement or suppression of facts. When the petitioner disclosed the receipt of the price adjustment money in receipt respect of the 11th bill in the audited balance sheet as well as and filed before the income tax authorities, and the act of the petitioner in not paying the GST in respect to the price adjustment cannot be regarded as the willful suppression of material facts by the petitioner, as the fact of receiving the amount has been disclosed by the petitioner, and mere failure to pay GST on the bona fide belief of the aforesaid is an omission and cannot be equated with the deliberate non-payment. It is asserted that there has been deliberate it is admitted that there has been no deliberate attempt on the part of the petitioner to escape the payment of duty. Such omission does not amount to willful suppression of the facts of the petitioner. Further, petitioner disclosed the information received of the price adjustment money in the annual balance sheet, auto balance sheet, ITR filing, as well as GST annual filing. The petitioner, as per Rule 66, affirmed and declared before the GST authority that the amount has been received by them in declaration so and so, and therefore there was due intimation of the same to the department. Accordingly, the fact of receiving money has been disclosed by the petitioner in the returning authorities, and there has been no deliberate attempt to evade the payment duty for which there was no suppression of facts. The mere omission to pay the duty on the GST on bona fide belief does not amount to suppression of facts. The proviso to Section 74(1) is also to the same effect, which states that suppression of facts means non-declaration of the facts or information which a taxable person is required to declare in the returned statement, report, or other document. In the instant case, the petitioner declared all material facts in the audit balance sheet, ITR filing, and GST return filing. The petitioner is, as per Section 66, affirmed and declared that the GST authority that the amount has been received by them in the declaration that it's so. Therefore, there was no intimation. There was due intimation of the department according to the suppressed fact. The respondent authority in the impugned order SOCO notice have failed to demonstrate that the petitioner intends to evade the payment of duty. The respondent authority has also failed to take into consideration that the petitioner had disclosed the information regarding the receiving of the price adjustment money, its adjustment balance sheet filing as well as the GST return. The petitioner disclosed all material facts, and there has been no willful misstatement or suppression of facts. According to the case of the petition, does not fall within Section 74(1) of the Act. The apex court in so and so has clearly held that mere failure to pay duty and to take out a license which is not due to the fraud, collusion, or misstatement, suppression of facts, or contamination of any of the provisions is not sufficient to attack the extended period of limitation. It is submitted the petitioner had disclosed the fact of receiving this amount in the audited balance sheet of petitioner and the filing returns income tax and the GST return, and also while filing the returns under the annual GST. The petitioner, on the basis of their understanding of bona fide belief, so So, my lord, the mere fact that the petitioner has not paid the taxes on because on the bona fide belief the petitioner was at that time under the impression that the petitioner is not liable to pay the tax. So this will not come to a case under section 74(1) for willful fraud or, my lord, the suppression of material facts, my lord, with the intention to evade the payment of tax. The case of the petitioner, my lord, squarely falls within the, my lord, all the judgments which have been placed before lordship, which has been all of judgments have been considered by lordship, my lord, in the case of Nirmal Kumar Sharma and subsequent all other judgments which your lordship has delivered, my lord, on the issue of the Finance Act of, my lord, 2017. And thereby, my lord, the question, your lordship, in fact, in one of the cases also, exercise beverages also, my lord, where the question of classification was there, my lord, of the item, your lordship has held that the simply because of wrong classification of the item will not amount to suppression of the material facts or willful intention to evade the payment of tax. And in this present case, my lord, there is apparently no suppression of facts. The assessing authority has come to the conclusion that it was the duty of the SSC to self-assess and pay the taxes properly as per the Act and rules, and since it has not been paid, and thereby, my lord, simply the language of the section has been reproduced, which cannot be, my lord, the reproducing the language of the section will have come to the conclusion has been arrived at. The conclusion must be on the basis of the facts, and the conclusion must be on the basis of the materials available on record. In view of the above, my submission is that, my lord, the impugned so-called notice which has been issued in section 74(1) of the Act is absolutely illegal and without jurisdiction. And as much as the respondent authorities assume the jurisdiction which is not vested on them without fulfillment of the preconditions of the section 74(1), and therefore, my lord, the said notice is liable to be set aside in cost.
Yes,
Page 132.
132.
Very quick.
Show cause.
Covered notice under section 74(1). Paragraph 1. Mr. So and so is proprietor of so and so. So and so, the notice is engaged in providing work contract service to the chief engineer.
74 is to suppression.
Suppression of the extended period of limit.
Parameter to section 73(1) my lord, of the Finance Act.
Paragraph 2. Diligence of evasion of tax. This was developed by the officers of the Director General of GST Intelligence. What is job? Herein the referred to a DGGI regarding GST evasion by Messrs. Kalita Sancho by way of scrutiny of GSTR 7, return of a mode, and on analysis of the GSTR 7, return of the notice, it appeared that they have provided work contract service to MORTH, but has not charged the GST liability. The notice has received an amount of rupees 36.7 crores, but filed nil GSTR 3B return for the period 22-23 on the basis of fact investigation against the notice covering the period from so and so was proposed, which was approved by the Additional Director General of so and so, and investigation against so and so, finding thereof. Paragraph 3.1. Investigation was initiated under section 67(1) of the GST Act 2017 by way of conducting inspection at the principal place of business of the notice on 6/12/2023. During the inspection, the notice was asked about the amount of rupees 36.47 crores approximately received by way of received by the firm in the financial year 22-23 as declared in GSTR 7 return of their services recipients. The notice informed by data dated 6/12/2023 RUD1 that the amount of rupees 32.7 crores and rupees 3.687 crores were withheld amounts which were paid in the financial year 2023. The notice by data dated 6/12/2023 submitted a notice to proceed with the work order and final bill amount dated 11th March 2021. Payment of payment dated.
So therefore,
investigation was
The-
carried
the
out.
Ground for invoking 74.
Yes.
Is that they did not charge the GST.
Yes, this is the basic, and why suppression they submitted return, it was nil. They did not disclose anything. During investigation, they said something else. That in paragraph 3.1, they submitted with our lordship, they stated that investigation was that the finance their withheld amount which were paid the financial 22-23. This is not a suppression of fact. Then what constitutes suppression of fact? Simple notice was issued. Document please to come. Page page 147. Page 147, paragraph 8. Now, therefore, so and so, proprietor of so and so, called upon to show cause before the additional joint commissioner, office of the principal commissioner, Gauhati GST commissionerate, within 30 days of the receipt of the notice as to file GST amounting to rupees so and so. Under above not be demanded and received from the term of so and so. Then 8.2, GST paid by the noticee after initiation of the investigation by way of filing DRC 3 dated 32/2024, as detailed in paragraph 3.3 above, amounting to rupees 30 lakh, and so allowed to be not to be appropriated with the confirmed demand mentioned at paragraphs 8.1 above. So lordship, notice was issued asking them to show cause to file.
Only notice is under 74.
Yes, lordship. Lordship, we have investigation was carried out, and in paragraph 3, we have detailed, lordship, why was invoked. Paragraph 3.2 also, lordship, detail has been given.
All right.
Lordship, I prepared a written submission along with some judgments. Lordship, I am relying on one judgment of Andhra Pradesh Court from by the Honorable Supreme Court. It says that non-filing of the return, suppression of fact. Here, lordship, what happened? They submitted return, but nil was shown in the particular column. Non-submission, that was non-filing of the return.
My lord, may kindly see page 146, my lord.
146.
My lord.
Yes.
You'll also find this is a discussion about suppression of the facts by the OCC.
Sorry?
Suppression of facts by the SCC, my lord. And this is, you'll also find first, they have only discussed about the, my lord, the section 74. And thereafter, my lord, 7.2, I have read it. 7.3, I have read it, my lord. And 7.4 and 7.5, there is no discussion. It simply says about on the basis of 7.1. And 7.1, there is no finding at all.
What do you say about the judgment which has been referred?
Which judgment, my lord?
Some judgment Mr. Kyal says is.
My lord, he is saying there's non-submission of the returns. I have submitted the return and shown it as exempted.
Where is the judgment of the Andhra Pradesh High Court?
I have given the page
Okay.
7.
There are Supreme Court judgments, Andhra Pradesh judgment, which what will do?
No, he says that the judgment has been upheld by the Supreme
Yes,
Court.
lordship, page 6.
SLP dismissed, no?
SLP dismissed.
Having heard the learned lordship, pleased to see. Having heard the learned counsel for the appearing for the petitioner and having gone through the materials on record, we see no ground to reasons to interfere with the impugned order passed by the High Court of Andhra Pradesh at Amravati. Especially petition is
The
according
question of law has not been decided.
Yes, lordship, that is correct. But lordship, when the
Well, that will remain to the judgment of
has
the
been upheld, so lordship, that
Judgment upheld It's not upheld, it shall be dismissed.
SLB dismissed, that means Lordship,
The question of law has not been discussed.
So the judgment of the Andhra Pradesh has attained finality,
Yes,
but
Lordship.
this will not amount, to a judgment of the Supreme Court.
No, Lordship, correct, but till date, Lordship, this judgment not in the field, Lordship.
All right. No, no.
But there are so many judgments of the Supreme
We are
Court.
only trying to understand that whether the judgment, the legal issues have been upheld
So that is
by the
not,
Supreme Court,
not discussed.
not discussed.
Well, the judgment of the Andhra Pradesh High Court.
Fact of the case, Lordship, as I pointed, I read out to you, Lordship,
Yes.
that there is a suppression of fact because their investigation was carried out. They appeared, they submitted, Lordship, something has been stated before the speaking of.
Well, your Lordship judgment has not been carried in appeal. They have all attained finality. The judgment,
Facts of that case is quite different.
facts will always be different. It has to be, facts cannot be the same.
Yes, Lordship. Then Lordship, that has to be applied. Then the law has been applicable in this case also.
The law has to be made on the basis of the facts. It has to be applied. If the facts are the same, then it is a covered matter. There was no argument is necessary.
My humble submission is not covered yet.
Yes, I am not saying it is a covered case. Where I am saying covered case, I am only saying that the law which has been laid down by this court, that is only. I have never said that this is covered. Otherwise, there was no necessity of argument. 1 minute we could have said it is covered.
Third, counsel for the parties is reserved.
Sorry, my lord, I was in different room. We are seeking the benefit of Supendra Bhattacharya's judgment or the Supreme Court. They are supposed to, with all these persons are working in 87, 85 and all. It is admitted.
Yes. Mr. Gugoi.
My lord, a coordinate bench, my lord. This,
Where it is not applicable.
no. It is hesitated, my lord, it is applicable. But there is a some indications that we can carry out a verification, man.
What the judgment says. Export judgment also says the same thing. Paragraph 79.
That line, my lord.
You are in which posts?
On the Khalasi,
Grade
work charge and grade 4.
grade 4. All grade 4.
Yes.
Working under
Master, the PHE and PWB.
PHE and PWB.
One is PHE, is
Four, item
WBC 51723.
item 4.
Item 4. PHE and the other one is PWB. Also one I can see the date when they were appointed.
Give us, I think we'll dispose it off.
Yes. I'll do that.
Third
Item
grade 4.
5, my lord, that will be Mr. Thorpe, PWB.
Dispose.
I'll Paragraph 17.
Yes. And 5 and 3 and 4.
Application for appointment of arbitral arbitrator.
Yes.
So the respondent and the petitioners are partners and there is no dispute about the arbitration agreement. A notice has been issued, Lord. Page 55 is the note.
Where is the arbitration clause?
Page 18, Lordship. Para 19. That any dispute arising out of this deed of partnership or out of partnership business shall be decided by arbitration and shall not ordinarily be dragged to any court.
Where is your notice?
Lordship, page 55. 11, page 58. Para 9.
Yes, you are appearing for all. The respondents.
Lordship, all respondents. Lordship, there is no dispute as such between the partners. The Lordship may see the arbitration notice, para 9 at page 58. Thus,
58.
para 9, Lordship. That it is thus evident that disputes and differences have arisen between the retiring withdrawing partners and the remaining partners, firstly concerning the determination of a fair market value of shares and buyback of transfers of shares held by retiring withdrawing partners in the partnership, and secondly concerning steps for retirement of the retiring withdrawing partner. Concomitantly, in terms of section clause 19 of the partnership deed dated 21/12/2020, the dispute is now to be solved by arbitration. Here, Lordship, what happened, the partnership business was closed during the COVID, which I have averred in my affidavit in opposition, which is also accepted by the petitioner in his affidavit in reply. Now, Your Lordship, the business is closed. The petitioner is asking for his 10% share of the partnership firm, which amounts to 1,67 lakhs. We have already, by various letters, have informed the petitioner that if you get a buyer of the partnership business property, we are agreeable that we may sell and each of the partners may get the share of the property.
He is a retiring partner.
Lordship, the business is already closed during COVID. The averment is at para A. Para 7 may be seen of my affidavit in opposition at page 62. The answering deponent states that petitioner, by its letter dated 30/12, had calculated the market value of its share at to be at 1,67 lakh, which was highly exaggerated.
So what is there in the agreement? Partnership deed, what is there?
But Lordship, the para clause 18 at page 17. That any of the partners may retire from the partnership by giving notice of 1 month to other partners. The retiring partner shall be entitled to be paid by the remaining parties hereto the credit balance standing in his or her name and the profits till date of retirement. In case of retirement of a partner, the value of goodwill shall be taken as nil. Now, Lordship, the partnership business is already closed. The mill is lying vacant. As soon as we get a buyer.
No, but the agreement says that he is entitled to be paid by the remaining parties the credit balance standing in his or her.
We are agreeable to pay the amount.
Pay it and close it.
Lordship, we are agreeable, but the market, the mill is already closed and there is no buyer as such of now. But
this is not the condition here. You are supposed to pay him on his retirement.
Lordship. But
whether you'll pay him after selling of the business or something is not the mandate of the agreement. The agreement is you have to pay him.
Lordship, but the business is closed. The partners have no other source of.
That is the dispute.
Lordship, the arbitrator will only decide that the amount, Lordship, then thereafter the other partners cannot pay as of now, as and when we
get. We don't know. That's the dispute to be decided, that in terms of this, what is to be done. In terms of this agreement,
Lordship,
you have entered into an agreement where it says that you retire and you give him the
credit balance
standing.
And he is asking for his 10% of share, Lordship. This is about the credit balance. 10% of share is 1,67 lakhs.
Credit balance
and profit.
And the profits.
Lordship. But
till the date of his retirement.
Lordship, the Supreme Court has held, your Lordship knows that the two criteria which are to be fulfilled in a Section 11 petition is that if there is an arbitration agreement and if there is an arbitrable dispute. Here in this case, there is an arbitration agreement that is not disputed. But there is no as such of dispute between the parties, your Lordship.
Why do you say that?
Lordship, the mill is already closed, the business.
Do you dispute his claim that he has not been paid the credit balance?
I don't dispute that, Lordship.
You dispute the fact that the profit standing in his name till the retirement has not been paid?
Lordship, no, I don't. He is asking for 1,67 lakhs.
He is asking for whatever amount. We are not concerned with that. We are asking in terms of this agreement.
Lordship.
In terms of this clause, there are two things you have to give him.
Lordship.
Amount standing credit balance in his name
Lordship.
and the profit.
Lordship.
Now, your claim that the money is not there, it is only be available only upon selling the business, etc.
Lord,
It's for you to decide. But to say that because of that there is no dispute would be correct. It will be correct to say that there is no dispute. The dispute has arisen because you have not paid.
Lord.
If you need time to resolve this issue with the petitioner, you take your time and attempt to see that it can be resolved.
Lordship, in that case, after vacation, a date may be given. If not done, then
Since last 6-7 months, we have tried, but they did not turn up.
Lordship, one of the respondents' son's marriage is fixed on 22nd of June. So just after vacation, one date may be given and it may be disposed of on that day.
Have you invited him to the marriage?
Lordship, to that instructions I don't have.
To ensure you invite him to the marriage, I'm sure it will be sorted out.
Lordship.
The dispute between the parties, the petitioner is aggrieved by non-fulfillment of the terms of clause 18 of the partnership deed, whereby upon retirement from the partnership, the retiring partners, namely the petitioner, is entitled to be paid by the remaining partners the credit balance standing in the name of the petitioner and the profits till the date of retirement. So, it submitted that these not having been paid, the dispute had arisen between the parties, and pursuant to the notice issued by the petitioner under section 21, the petitioners did not, the respondents did not concur on the matter being resolved through arbitration. Mr. Sahibala, appearing for the respondent, submits that essentially there is no dispute between the parties. The respondents are agreeable to pay the amount, pay to the petitioner the claims made. However, in view of the business being closed during the COVID, and an attempt has been made by the remaining partners to sell off the business, to find the purchaser for the business, not having materialized, they are unable to pay the amount claimed by the petitioner. So, the counsel for the respondents also suggestion by the court that whether an attempt could be made to resolve the dispute, the counsel for the parties submit, and the matter be listed after 4 weeks. Stop in the event any dispute is resolved mutually, then the parties will inform the court accordingly. Release this matter again on 27th of July.
Lord, much deeply.
Yeah.
Before he starts, I am appearing in item number 15. There are certain development in this case, Your Lordship. The petitioner participated in a subsequent selection process, got selected, medical is also done, Your Lordship. Formal appointment letter has not yet received. Therefore, this petition may not pursue this matter, Your Lordship. Therefore, Your Lordship may fix it some other day. I will take a formal instruction from him. Right.
Item 15.
Item 15.
Item 15, it is submitted that the petitioner has participated in a subsequent selection process, and he has been selected and has appeared before the authorities for medical evaluation, and the confirmation and selection results thereof, the confirmation thereof towards his appointment are awaited. The learned counsel therefore submits that the matter should be deferred, be listed after 4 weeks.
Sure.
prayer made is not objected to by Ms. R. Kakuti.
I'm waiting for respondent number 2 and 3.
Appearing for respondent 2 and 3, Mr. N. Decca, senior counsel.
I am in the other.
You are in the other matter, right? Accordingly, this matter be listed separately
Yes.
and after 4 weeks.
Diploma.
Yes.
My lord, petitioners, my lord, they completed their apprenticeship training as boiler attendant under the respondent. My lord, the training was done under the Apprenticeship Act 1961, and the training was imparted by Indian Oil Corporation Limited. That is the respondent number 1. My lord, they started their training from 11/2/2022, and the training was completed on 10/2/2024. It was a 2 years training, my lord.
Yes.
After completion of their training, my lord, they were given the provisional certificates, which are available at page 16, 17, and 18. These are my provisional certificates that I have completed the training, successfully completed the training. And my lord, the final certificate was supposed to be given by the BOPT or RDAT, that is the Board of Practical Training and Regional Directorate of Apprenticeship Training. That is the respondent number 3. Now, the final certificates were issued by the respondent number 3, but therein it is mentioned as Bachelor of Science. Kindly come to page 19, my lord. I'll show one certificate. All 3 certificates are same. Page number 19.
Yes.
So, my lord, will find in the subject field of Bachelor of Science, it should have been boiler attendant. Here is a mistake. Now, the respondent number 1 doesn't impart any apprenticeship training with the subject Bachelor of Science. That is not there only. Boiler attendant is there. So, this mistake was committed.
Yes.
Then, my lord, on 27/24, the respondent number 1 issued an advertisement at page 27. At page 27, the advertisement is annexed. And my lord, at page 27 itself,
Now, at page 19, you say that this was wrongly issued.
Yes.
Did you file any representation before the authority that it needs to be corrected?
Yes, my lord. In fact, this was our second prayer before the writ petition that they may be directed to correct. But on the basis of our representation during the pendency of this writ petition, they have corrected it and they have issued us corrected certificate. And we have brought that on record by way of additional affidavit also.
Okay.
That is on record. Now this is corrected. So one of our prayer have been addressed already. Now we are on the another prayer, only one prayer survives in this writ petition. Now, my lord, the page 27 is the advertisement, my lord. So here is in the first page itself, junior engineering assistant, power and utility. So we had applied for this post.
Yes.
There were total 10 posts in Gauhati. 4 posts are unreserved, 3 posts are reserved for OBC NCL, and petition number 1 falls under the OBC NCL category, and petition number 2 and 3 falls under the unreserved category. Now, my lord, we applied, admit cards were issued, and then computer-based test was held on 29/9/2024. And at page 62, they declared the result. Page 62 is the result, but our name, we are not qualified here. Not disqualified. And why we were disqualified, my lord, I'll show. Page 83, 85. My lord, may kindly take up additional affidavit, my lord, it was filed on behalf of the petitioner, my lord. I'll say the page number is 83. 83, lordship. At the bottom, remarks if any. Apprenticeship certificate submitted does not have endorsement from Boiler Authority of Assam as equivalent to BCC second class. So the Boiler Authority had not endorsed the certificate they are saying. This is the reason for rejection, my lord. And our case is that it is a mistake committed on the part of the respondent number 1. While filling up the form, they have entered it as Bachelor of Science, whereas they should have entered it as boiler attendant. Since the wrong entry was made as such, the certificate, it came as Bachelor of Science. And my lord, now that is our case, my lord. And the case of the respondent is that respondent. My lord, kindly take up the additional affidavit filed by the respondent number 1 and 2. It starts from page 143.
Yes.
Page 145, para 4. So, my lord, in the advertisement,
145 is a model contract for apprenticeship.
my lord, page 145.
145 here is the model contract of apprenticeship.
Service copy. My lord, I am reading from the additional affidavit for and on behalf of respondent number 1 and 2.
You get the page numbers corrected.
My lord,
Take time to go through the records and align your page numbers. Otherwise, you'll be
yes,
Our page
Voting in-
numbers are aligned. Same thing is there in my brief also.
but here it is different. 145 is something else.
For the 2 additional affidavits have, my lord, I think, serious amendment.
Continuous pagination is here.
We'll have to paginate that, our brief case is allowed.
Do it. Otherwise, it is difficult.
yes,
going
yes,
through
I
this
understand. It's a
list of
bulky
people.
record.
What your lordship is reading is page number, I think, 138 here, or 133 in our brief. Really.
Then we align, my lord.
There are 3 page numbers here. 2 of them struck off. 1 is available. Align the page numbers.
We align.
Release this matter after 1 week.
Date kindly.
Next Thursday, my lord, if it is possible, my lord.
18th,
18th.
based on Thursday.
18. Obligement.
The request of the council.
This my lord, I'm bidding for the department water resource. Look, here some out of court settlement has been arrived between the parties, and the settlement is now pending for approval of finance department, my lord. So, my lord,
We're closing this petition then. None appears for the petitioner on second call. When on second, it is submitted by MS P. Chakraborty, learned counsel appearing for the Water Resources Department, that an out-of-court settlement has been arrived at by and between the parties. Under such circumstances, arbitration petition so and so stands dismissed. Interim order, pending either also dismissed. Yes.
only thing that has been left out is DCRG. Now the government has filed an affidavit stating that because I have not completed, the petitioner husband has not completed the 20 years. Only completed the, that's why the DCRG is not entitled. And in a similarly situated case, there is a judgment of our division bench, my lord. Dollywood case has been that fact has been dealt with. Wherein in that case the 14-year service where petitioner was doing have done only 14 years, and the honorable division bench has held that it being a substantive post, so he is entitled for the benefits of all the pension. May I rely upon that judgment, my lord? That is 2010 to GLT 147. Pension would I have not found anywhere that that the employee has to complete the 20 years for entitlement of the CRC. Petitioner died. Petitioner husband died while serving, while on duty, while serving in the on the highway. My lord. He was a junior engineer, PWD roads.
The Chakrabarti under what provision? This requirement?
Because here in this case, this is
So this is what, this is
Assam Services Pension Rule.
state government.
State
You are representing?
Accountant General.
Twenty years.
20 years. Because his service was not confirmed. So in case it is not confirmed, the 20 years continuous service. It's been given pension and the GPF amount. Only the DCRG part is remained.
No, this is for pensionary benefits. You've already given, you've given the family pension,
Yes, pension she is getting.
family pension.
And GPF also has been released. The DCRG part for that.
What is included there?
That's calculation.
Component?
Component. One 136 deals with that lordship. Rule 136.
One 136 is
135.
family.
135. 135. That come retirement gratuity.
Five years qualifying service.
So basically,
5 years.
5 years. But take our affidavit lordship. The last annexure says so why it has been refused.
It's a communication, but doesn't explain why.
Not completed 20 years of net qualified service, and his service was also not confirmed. Hence, this year he is not admissible. This will make communication to the department, and the copy was also forwarded to the petition.
On what basis? What is the claim?
For that specific instruction, I will not may take some time, may allow me some time. So this case was dealt by the SK Medi, is out of station today, Lord. And let me go through that judgment also. My friend is relying.
Specified in 135(2).
Okay. And one basis that instruction has been said that clarification has to be say from the department. Was the petition lacks all those detail when appointed, when regularized, whether confirmed thing and decking.
Assuming it was not confirmed, then the department will take steps to.
That lordship, the Sanjita or the similar type, whether that relaxation can be applicable or not.
No, that Sanjita Roy will be applicable if there is some confirmation. Was he confirmed? Was he receiving pension?
That is not clear for us.
Huh?
He is now receiving pension.
Pension has been given.
Family pension.
Family
Then obviously confirmed.
But why that note was given?
Why that note? We don't know. Who has given that note?
It's just sent from the accountant AG
Get
office.
it. Get your clarification by Monday.
Lordship.
Or we'll give you 2 more days time. Wednesday. Release this matter again on Wednesday. Enable Mr. B. Chakraborty, learned counsel, appearing for the accountant general's office in respect of the communication dated 18 November 2015 issued by the Senior Accounts Officer, the Under Secretary, Government of Assam PWD, Building and NH, that the petitioner having not completed 20 years of
Husband.
petitioner's husband having not completed 20 years of net qualifying service, and his service was also not confirmed, hence DCRG is not admissible. Based on 17.
Right.
Matter to be treated as partner. Supply. Yes.
Lord, the petitioners were, my lord, promoted as deputy ranger under the rules, and they were, my lord, reverted without following any process of law. Now, my lord, the facts are like this, my lord. While the petitioners were working as, my lord, Forester 1, they had undergone a training. And in that training, they came out successful. Now, there is a set of rules, my lord. Matter is a very narrow compass, my lord. Forester. My lord, we have Assam Junior Forest Service Rule 2005. Let's come to Rule 6, my lord.
6.
Promotion to different cadres shall be subject to the following reservation. All vacancies in the cadre of deputy ranger, gamekeeper of equivalent rank, status shall be filled up by promotion of members belonging to the cadre of forester. A cadre of forester 1, assistant instructor of forest school of equivalent rank and status satisfying from.
You are appointed as
Deputy ranger, promoted as deputy ranger, and we were, my lord, forester grade 1. Forester training.
You were forester grade 1. You were promoted as deputy ranger.
Yes. Now we have been reverted.
Okay.
Forester trainee securing second and third position with not less than 70% marks in the final examination of the forester training school, and with continuous service length of not less than 5 years. Then let me read it, then I'll explain. All members due for promotion to this category shall be eligible for promotion on the basis of seniority cum merit with a service length of not less than 10 years, including at least 3 years service in wildlife areas, and from the select list to be prepared by selection committee. List of eligible members due for promotion in this cadre shall be prepared on the basis of seniority cum merit and submitted ordinarily every year by the respective circle conservator with ACR and performance report ordinarily for previous 5 years to the head of the department for placing it before the selection committee. Well, my understanding of the rule is Rule 6 prescribes 2 types of promotion. One is, my lord, forester who secures second and third position with not less than 70% mark in the final examination of the forester training school and who has got continuous length of service of not less than 5 years. Now, my lord, everybody is deputed to training. Out of those who secure position and who have qualifying marks and the qualifying service, then they will be straight away promoted. Promotion to this category, there is no question of any DPC. Promotion under the second category, which is seniority come merit. For example, my lord, can it so happen? I am deputed for training. I secure higher position. I have got 5 years qualifying service. Then I am promoted. Then, my lord, there are still vacant posts. So for that, second category will come based on the seniority of the forester grade 1, who has put in not less than 10 years and includes 3 years in wildlife areas, he will be promoted. Now what had happened, my lord? Having regard to this rule position, now let me place the facts. Now, my lord, what had happened? We were promoted at page 65. First, let me place my position in the training, page 56. Kindly see, my lord, from page 56, Dayananda Rongpi stood topper in the 6 months induction training for Forester Convention 1st January to 30th June 12 is awarded with the Forest Minister's Award. So this is how are the certificates. Then my lord will kindly come to page 65. This is our promotion order. Subject to reversion without notice and without assigning any reason thereof, until further order and without prejudice to their intrinsic seniority, the following forester grade 1, who stood first, second, and third, rank with 70% marks and above in the final examination of the 6 months induction training of the forester training course and completed 5 years of service, are hereby temporarily appointed to the rank of deputy ranger in the scale of so and so, so and so, so and so, plus other allowances as admissible under rules. And similar, under provisions of Rule 6(1)(I) of the Assam Junior Forest Service Rule 2005. Kindly similar the list. Dayananda Rongpi, he got 96%, 90.6. That is petitioner number 1. Satyajit Ray is petitioner number 2. He secured 89.9. Then below petitioner number 3, just serial number 4, Manik Tiso, he secured 80%. Then serial number 5, Amarjit Hansu is petitioner number 4. Don Bora, petitioner number 5. Olokesh Das, petitioner number 7. Manojit Das, petitioner number 8. Tikshon Jyoti Bokolial, petitioner number 6. And Gayatri Gogoi, petitioner number 9. Now, my lord, they were promoted. Then what had happened, my lord? By an order at page 69, my lord, in the interest of public service, promotion order in respect of Forester 1, who stood first, second, and third rank in the final examination of Forester training course to the rank of Deputy Ranger made by this office is hereby kept in abeyance with immediate effect. So initially the order of promotion was kept in abeyance. Then what happened, my lord? On similar fashion, promotion was also given to some forest guards. Their cases
Promotion to which post?
from my lord forester to forester grade 1. Sorry, forest guard to forester grade 1. No. That order lordships will get at page 75.
Yes.
Now kindly similar, this is speaking order dated 2nd of July 22. This office order wherein 12 number of forester grade 1 who stood so and so with 70% marks and above in the final examination of 6 months induction course of forester training course and completed 5 years of service were promoted to the rank of deputy ranger. Now this is important. And 8 number of forest guards who stood first, second, and third rank with 70% marks and above in the final examination of 6 months induction course of forest training course and completed 5 years were promoted to the rank of forest guard. So there are two batches, my lord. One batch is the petitioner and another batch was forest guard to forester grade 1. Now, my lord, they were also promoted. Then, my lord, they discussed the position. Please come to, my lord, page 77. The promotion made by so and so dated 29/6/21 are liable to be set aside. There are serious infirmities in the entire promotion process followed as above observation, and these need to be addressed before considering any such promotion under Rule 6(1)(a)(1) and 6(1)(b)(1) of the Assam Junior Service Rule. So, what had happened? The promotion of the petitioners from forester grade 1 to deputy ranger and for the promotion of forest guard to forester 1 was set aside. Now, my lord, these foresters, they moved this honorable court against their this order, and this honorable court allowed the repetition, which your lordships will get at page number 79. I'll have your lordships kind attention to page 84. Paragraph 8 at page 84. After a careful scrutiny of the Rule 6 of the Rules of 2005, I do not find any provision which permits forest guard completing 3 months training to be promoted in the next higher rank of forester grade 1. Moreover, even if it is assumed that other forest guards are eligible for promotion, the promotion already given to the petitioners and notified by the competent authority would not have been revoked in this fashion without giving an opportunity of being heard to the petitioner. Under these circumstances, this court is of the unhesitated opinion that the order dated 2/7/22 is not only illegal, but the same is also a violation of the principles of nature and justice, making the same wholly unsustainable in the eyes of law. So, my lord, the order by which promotion of the forest guard from forest guard to forester grade 1 was reverted, that was interfered with by this honorable court on the ground that this was passed in violation of the principles of nature and justice, not on any other point. So, my lord, pursuant to this order, the promotion of the forest guard to forester grade 1 has been restored. But because we have not filed any petition, my lord, our promotion have not been restored. That is why we are before your lordships.
So why was it
yes,
reverted back?
Yes. To know that, we'll have to go to that order at page 75. Please come to page 75, by which the promotion was cancelled.
Yes.
Please come to the observation of the committee part. Merit of promotion. Promotion made by office order dated 29/6/21 may not stand legal scrutiny owing to the following grounds. Promotion. Rule 6 nowhere mentions that forester trainee having completed 6 months induction training alone hold eligibility for promotion under Rule 6(1)(ai) and not the ones having done refresher course of 3 months. Forester trainee 49 to 54 batch who had done only 3 months refresher course were deprived of the benefit of promotion under 6(1)(b)(1). This is further compounded by the fact that no apparent rationale exists as to which forester is recruited, in which recruitment batch would get nominated to which year and which type of training in the forest school. Nomination to a given training in the forest school were made from multiple recruitment batches, and the schools had no say in the same. Order of merit then was then assigned to the forester trainee in such mixed group
and was reckoned for the purpose of promotion to the next higher rank. Because of mixing of different recruitment batches in the training, forester training belonging to the same recruitment batch were sometimes assigned so-and-so position in more than one training course. These were then promoted to the next higher rank under 6(1)(a). Similarly, in case of forest guard, a batch of 3 months training had not been considered for promotion. Backlog of untrained staff imparted 3 months training and having performed meritoriously on academic ground had been deprived of promotion, which new recruitment could avail despite getting lower rank than the former. Available office record could not validate such disparity. In view of such anomalies, there is a need to establish harmony between the state training policy of 2012 and Assam Junior Service Rule through an amendment to the latter so as to bring clarity in the eligibility criteria for promotion with respect to the training type, duration, and order of merit. Since the revised training rule so-and-so and the subsequent approval from Dispur dated so-and-so and later dated do not deal with this issue, need for amending so-and-so rule persists. Selection committee has provision to create it under Rule 6.2 of the Assam Junior Forest Rule should have been constituted to examine the promotion
Now,
proposal.
after you are brought
Yes.
down,
Yes.
what has happened? What is the position?
The
on the
position is
field?
below, we have been reverted.
You are reverted as
Forester.
Forester 1.
One.
It's still working as
Yes.
Forester 1.
Yes. Now,
Now, in what about the other juniors or somebody?
No, now what had happened, Milord? Some of the persons who got lower merit in the training, they have been promoted under the 2, Roman 2. Now they will become senior to us. Milord, what I'll submit
They
respectfully.
were promoted by a separate selection.
Yes, and under 2. Oh, of course, there is a status quo order operating. Na? Sorry, Milord, I'm sorry. There is a status quo order operating. Now, Milord, please come to the rule once again, because everything depends on the interpretation of the rules. Now, before that, let me make a submission.
No, if you are enjoying a status quo order, why are we hearing this matter today? What purpose?
No,
You are
Milord,
enjoying a status quo.
because, Milord, our juniors have been promoted substantive.
But you are holding the post of.
But Milord, eventually the question of seniority will come.
You are presently deputy ranger.
Deputy ranger.
By virtue of interim orders.
Status quo order.
Status quo. Juniors are also deputy rangers.
Yes.
So the question of whether their selection has to be given effect to over you would be a final decision in these matters.
Yes.
But as on date, you are at par, you are senior to them by virtue of the status quo. Yes?
No, Milord, all that I was trying, no, that is
Let him
clear,
complete.
Milord. What I feel is, Milord, as we find from order at page 72, they say there is no clarity in the rules. Because sometimes, while deputy
We are
person.
not on that. We are saying is it something that we have to hear it today, tomorrow, day after? We can have it after the vacation because you are protected by an interim order. It will require some understanding of the rules.
Yes, yes.
And deciding your rights qua the rules, and because apparently no selection committee was held and something was not there, what would be the effect of such a selection?
Actually, Milord, there is a Supreme Court judgment regarding Milord ranger. This is the all India pattern, Milord, and such promotion of rangers have been upheld and brought the judge.
That is different. That is
not different.
No, I can differentiate. That is in the mode of entry. That's a different ball game altogether.
No, all we are saying is that.
No, Milord, our anxiety is our juniors have been promoted substantively.
But you are still, you're protected.
True, but by virtue of it, Milord, fact of the matter is our promotion, by virtue of an interim order, we
are on that. It is not a case that you are reverted and they are promoted and now the further promotion is going to take place.
In fact, my lords, that forest guards, they went to read appeal also. Then,
why did they go to read appeal?
Read appeal, my lord, because there was a direction to proceed against them
if they're found, but because at page 8 of that order, even the court holds that there's no provision for the forest guard to be promoted as the forester one. It deholds the rules. In that case, there was a direction. I have filed my affidavit in opposition that the court, though
We'll hear it after
this
the
forest guards,
vacation.
but they are now facing DPs, my lord.
Mr. Chaudhary,
Yes.
we'll continue after the vacation.
The interim order which is operating in the lot, it is hereby provided that respondents shall not fill up the 9 posts of deputy ranger from which the petitioners have been diverted without leave of this court. That means, my lord, in our post nobody can be appointed, but there is no, bar to promote others.
By which order is it?
Page, yes.
This is the order 612.
Yes.
612.
Yes. 612. That means the post against which we were promoted, which those should not be filled up. But my lord, it does not mean that we are holding the post. I think we are not holding.
Anyway,
In fact, my lord, some of them,
we'll
some of the
continue
petitioners
the
are
hearing
also
immediately after the vacation.
My lord.
Because this will require some interpretation of
Some hearing, yes.
let this matter be listed again on. Can have it on 23rd of July.
23rd, my lord.
23rd of July.
Pension method. I was retired from my services, Lordship, on 29/0/24, Lordship. I was serving as a constable, Lordship. Thereafter, Lordship, as per the provision, Lordship, the department has provided me provisional pensions, Lordship. And I was asked to submit the necessary documents for the pension and other benefits, Lordship, along with the documents of the nominee. Lordship, my wife was nominee in the service book, Lordship, but due to some marital dispute, Lordship, we are living separately, Lordship, although we have not separated legally, Lordship. Lordship, thereafter, I have submitted all my documents, Lordship, but I could not find the documents of the nominee, Lordship. She denied to give me her documents, Lordship. Thereafter, I served 2 times legal notices.
Anyone for the respondent 6?
Lordship, respondents was cleared as party on earlier occasion, Lordship, by this honorable court, Lordship.
Yes.
Lordship, affidavit filed by the respondent number of 5, Lordship. Our stand is, Lordship, as because of Lordship, nominee has not submitted the required documents, Lordship.
The nominee doesn't want to submit.
Lordship, that's why the problem arises. Otherwise, no problem, Lordship.
Well, Lordship, there is a provision, Lordship, for the pension, Lordship. There is the office memorandum, Lordship. It is the office memorandum dated, Lordship, 29th April 1976, Lordship.
Where is it?
Lordship, it's some pension rules, Lordship.
Rule.
But in my book, it is on page 375, Lordship. Office memorandum dated, Lordship, 29 April 1976. As per this office memorandum, Lordship.
What is the date?
29th April 1976. Lordship. As per each number, Lordship.
No, this we'll have to first find out where is the OM. Relatable to which rule?
Regarding, Lordship, finalization of pension, Lordship.
tell us connected to which rule? Why are you giving your book? We also have books.
Lordship, regarding finalization, Lordship,
Relatable to which rule is this office memorandum in your book? So that we can also find it.
applicability and interpretations of rules, Lordship, it is
You find out, let us know. Find out. We'll call up other matters, you find out and inform the court master, we'll take it up again. Written submission.
I have already submitted long back. My side has also submitted one written submission.
Where is the shoppers? Where is the shoppers here?
Possibly find shoppers. Page 39 units.
There was some transfer on,
Some transfer.
on the
In
use
fact,
of.
what that comes from the show-cause notice, Your Lordship, Deputy Commissioner prepared it, and it was for onward submission to Mission Director. But this person who was in charge of District Mission Coordinator, Your Lordship, he issued the transfer order. This is the allegation. The recommended proposals to be submitted to the Mission Director SSA for approval. That you had effected some of the transfer by furnishing copies of the list of teachers approved and signed by the Deputy Commissioner, which was mailed for submission to the Mission Director SSA for approval, keeping the district administration in dark, which amounts to violation of rules and regulations. Which rules and which regulation they have not come up with that. Still, Your Lordship, initially I have replied by page 43, denying the charges, Your Lordship. That's a preliminary reply. Your Lordship will find para.
You were serving as?
At that point of time, additional deputy
ADC.
ADC, come, Your Lordship, district mission board. At that point of time, Your Lordship, charges were additional deputy. Now, while submitting this petition, first reply, Your Lordship, I also said that sir, I was not given an opportunity being heard and disposed Deposed at the time of enquiry so and so, additional deputy commissioner so and so, Barbada for reasons best known to him. Therefore, the report on the basis of which charge is brought against me was perhaps prepared by so and so, which the DMS might not be totally ignored in the matter, may kindly be considered as a complete irreparable and an act of injustice done to me.
Then whatever.
Then, your lordship, I went through the documents and then again
Another reply.
reply is 45. Your lordship, may I read this? Your lordship? That, sir, as Deputy Commissioner Borbeta agrees with the report of inquiry submitted by Sri Raman Sharma, SCS, Additional Deputy Commissioner Borbeta, as per order of the Mission Director Sarva Shiksha Abhijan Assam, and the aforementioned report is the basis of charge of misleading the higher authority and crossing discipline against me. As a faithful servant of government, I have nothing to say. That, sir, I was not aware of the provisions of the contract between TET teachers and the school management committee of the school. I also fail to understand why TET teachers followed verbal or SMS transfer order of any other officer, including the Deputy Commissioner, PMC, in violation of the contract signed by them with the respect to SMCs of the schools. It is not understood why the finance and accounts officer and district project officers, teachers, training SSA Borbeta in association with block mission coordinator prepared the salary bills and placed before the DMC SSA Borbeta and managed to get these bills countersigned, although they all knew that these were not valid transference by the contract. However, my counter signature of the bills did not cause any pecuniary loss to the government checker. As a part-time officer of SSA, I did not get sufficient time to go.
So what is the punishment imposed? Stoppage of one increment.
That is the
No appeal file.
No, appeal, your lordship, is there. Your lordship will kindly see. This is at page order of the appellate authority, your lordship, at page 50. Same authority. Appeal is disposed of by the same authority. Sitting authority.
Is this the disciplinary authority is the additional chief secretary?
Yes, sir.
And the appellate authority is also that?
Your lordship.
Huh?
Order is passed by the
Who is the appellate authority?
now for them, your lordship, it says governor. Now thereafter, your lordship, during this video, your lordship, subsequence of this punishment for 1 year. In the meanwhile, your lordship, promotions were given, your lordship, that was not given. This punishment is subsisting. And and in the meanwhile, I also got retired. So before retirement, I filed this writ petition. And during pendency of the writ petition, I retired on, your lordship, 36/2016. Now, your lordship, ground taken, your lordship, so far as this proceeding is concerned, I am concerned, your lordship, that my humble submission before this honorable court is that, your lordship, that the charge that has been brought against me would not come with misconduct. That's my first submission. Apparently, after going to the charges, your lordship, which is in fact it's very vague in nature, but still, your lordship, there is no allegation of your lordship that except that it should have been, your lordship, first go to the mission director and then the transfer order is to be passed to your lordship. Apart from that, no malafide is alleged against me. not, it is not their allegation that I have done this for certain benefits to be received. Then what rules and regulations I have violated, that has also not been clearly pointed out in the search sheet.
What about the records of the proceedings?
Yes,
Record
I have got the
probably-
record. Recording is, first of all, when he was posted in the Kolkata ADC, he was extremely entrusted for the district mission coordinator. His duty is to see look after this teacher affairs, but he without approval from the district mission director, mission Assam State suppose is a mission director.
Yeah, all right, we'll come to you. We just wanted to know the records.
Records earlier, your lordship has called.
Oh.
Record with me. I will show, but he admitted all these things.
That
We
I
have filed
already
affidavit, my
shown.
lord.
See, your only ground is that no specific clause is specified.
That is one ground. Now, second ground is your lordship.
So, is it your case that you are authorized to do these transfers?
Lordship, I am authorized to do this transfer, but your lordship, only point is this, your lordship, that this should have been routed through the mission director. Your lordship. That's what. Now, your lordship will kindly see that's the one ground, and second ground I am taking, your lordship, that ultimately, your lordship, it's an allegation of misconduct. Although I have admitted that I should not have done, and I have also very specifically submitted before the disciplinary authority that this is an inadvertent mistake on my part. More than that, there is nothing. And if that be so, there is not an inadvertent mistake, that there is a deliberate attempt on my part to violate, then there will have to be a finding given by the authority, and therefore an inquiry ought to have been conducted by them under section Rule 9 of the Assam Service Discipline and Appeal Rules. That has not been done. That is my second ground. And
So, the PROCEEDINGS is issued under what?
Rule 9.
Oh,
Then, your lordship, this should have, your lordship, my submission is that in spite of that, your lordship, that although I have said that I have committed some mistake, your lordship, I have specifically submitted that it is an inadvertent mistake on my part. Now, when it will have to be a misconduct, there will have to be some willful neglect of duties on my part. Whether it is willful or not, that will have to be find out from an inquiry, your lordship.
No, the allegation against you is that you have
A transfer order was transferred, or list of transfer was prepared. Your lordship, 39, your lordship will find this. Statement of allegation is at page 41.
41. So, you transferred 70 numbers of teachers.
Lordship, the deputy commissioner recommended proposals to be submitted to the mission director SSA for approval. Now, your lordship, it was prepared by the deputy commissioner, and your lordship, it was to be forwarded to the mission director, but your lordship,
Forwarded by whom?
forwarded by your lordship or through me, your lordship, since I am the district mission coordinator, it will have to be through me. Now, when it will have to be through me,
They were transferred on the same day.
lordship, those transfer orders were issued, your lordship. Your lordship may kindly come to 46, my admission.
Yes.
That's why it was not my intention to commit my act of indiscipline and mislead my higher authority. It happened inadvertently because of my high confidence level in the subordinate officer and staff of SSA. Therefore, I request the panel to consider my above submission favorably, and the third, which I hereby humbly may kindly be dropped into my supervision. Now, your lordship, it is nobody's case that had there been an allegation that there is a quid pro quo, your lordship, so far as this transfer order is concerned, then your lordship, matter would have been different, your lordship. And when I have specifically submitted that this is an inadvertent mistake on my part, your lordship,
then probably your lordship to hold it to be a your lordship misconduct, inquiry ought to have been your lordship conducted, your lordship, in spite of that, your lordship. But on the basis of considering this to be an admission of the guilt, your lordship, the order has been passed, your lordship. In my humble submission, your lordship, that should not have been the case, your lordship.
So see, it is not just that. You come to para 3,
Lordship.
page 45.
Lordship.
You are overburdened with duties
Lordship.
as additional DC, and therefore you're not properly apprised. This is also an admission.
No, your lordship, but your
Then
lordship,
number 4, that your mobile phone was used by some officers
Lordship.
with the SMS.
lordship. Then that is what your lordship. Ultimately, I have not denied that it was not sent by me. But what I have stated, your lordship, this was an inadvertent mistake on my part. Your lordship.
Inadvertent mistake, yes, but if it is an inadvertent mistake, also the authorities are of the view that it amounts to misconduct.
No, your lordship will kindly see, your lordship.
What is the definition of misconduct?
No, your lordship, I will come to that, your lordship. Before that, your lordship, therefore sees the order of the disciplinary authority. He has not at all, no discussion at all, your lordship, in this. There is no reason at all shown in this order, your lordship.
He has accepted the.
So that is what, your lordship. You will have to have some finding given on the basis of my reply, your lordship. What it says, your lordship, will kindly.
Was there an inquiry conducted?
No, your lordship. That's what, your lordship.
There was no inquiry conducted.
No inquiry conducted.
Inquiry conducted, but after inquiry conducted,
Let me complete. On the basis of my reply, your lordship, it is the disciplinary authority accepted it to be an admission on my part. Therefore, no inquiry is conducted, and this order has been passed, your lordship. And this order, that is one of my ground, that this order lacks reason, your lordship. And fourthly, your lordship, this opinion of the Public Service Commission, that also ought to have been furnished to me, your lordship. That has also not been furnished to me before taking action against me, your lordship. Now, your lordship, 1 year, this has a cascading effect on me, your lordship. My promotion I did not get because of this, your lordship. It's a minor penalty, no doubt about that, your lordship. But there are other penalties also. Censure, warning. Why those are not used against me, only this, your lordship? There must be some reason reflected from the order of the disciplinary authority, your lordship. And he has not even considered that.
No, because you have admitted the charges frame.
That is what, your lordship, I am submitting, your lordship, that this is an admission, but the admission is that I have specifically mentioned that it is an inadvertent mistake on my part. And when it is an inadvertent mistake or not, that will have to be, your lordship, find out from an inquiry proceeding, your lordship. Ultimately, these things have, your lordship, adverse consequences for the employee, your lordship. So far as I am concerned, I did not get promoted to the next higher rank, your lordship, because of this penalty, your lordship. Now, in such a situation, your lordship, the inquiry ought to have been conducted to find out whether it is an inadvertent, whether there is a quid pro quo, and it is your lordship may kindly note, even in the allegation, statement of allegation, they have not alleged that I have taken some benefit for issuing this order. That is also not there.
Is there any definition of misconduct?
Your lordship, I will show one judgment, your lordship, on that. This is part of that booklet, your lordship. So these are my grounds, your lordship, on which I have silenced this, your lordship. Ultimately, because of this, your lordship, I did not get promoted to the next higher post and retired without being promoted.
So essentially, you are agreed by not getting the promotion.
Yes, your lordship. That is what has happened.
So why the promotion was not given?
Because, your lordship, punishment was for one increment for 1 year.
1 year. You retired next year.
During the subsistence of that, your lordship, I retired.
So before the expiry of the punishment period, you
I
retired.
retired.
That's why, Your Lordship, I was not considered. Now, Your Lordship will kindly, on that, Your Lordship, this misconduct, Your Lordship. There is one judgment, Your Lordship, 1992 4 SCC 54, Your Lordship. Para 6, Your Lordship. And before that, Your Lordship may kindly come to that first order, Your Lordship, passed by the Honorable Court, where an interim direction was passed, Your Lordship. That Your Lordship will find. I am not paging it. Just after the submission, Your Lordship, I have annexed that order.
It is 24-2.
Lordship, 24 2016. There is a prima facie finding given by this Honorable Court while passing this order. May I read this, Your Lordship? Third so. Third paragraph. Petitioner is an officer belonging to the Assam Civic Service while holding the post of Additional Deputy Commissioner cum District Mission Code in Borpeta. A so-called notice dated 21/2015 was issued to him by the disciplinary authority under Rule 9 of the Assam Service Discipline Appeal 1964, read with Article 311 of the Constitution of India, as to why any of the penalties prescribed in Rule 7 of the 1964 rule should not be imposed on the petitioner. Allegation against the petitioner was that he has transferred 20 numbers of teachers by sending SMS or verbal communication without obtaining the approval of the mission director SSA. He had also transferred another 70 teachers without obtaining approval of the mission director. Therefore, petitioner was charged with misleading the higher authority and gross misdiscipline. Petitioner submitted written statement on 29/1/2015 and another one on 25/2015. In a written statement, petitioner explained the circumstances leading to large-scale transfers. By the impugn order dated 5/11/2025 passed by the Additional Chief Secretary of Assam Personnel A Department, acting as a disciplinary authority, it was held that the petitioner had admitted the charge framed against him and consequently, it was decided to impose penalty of stoppage of 1 annual increment on the petitioner. Petitioner had filed an appeal against the aforesaid order, which was rejected on 18/12/2015 by the same authority, that is the Additional Chief Secretary of Assam Personnel A Department, who had passed the order of penalty. While learned counsel for the petitioner contended that there was no admission on the part of the petitioner, learned standing counsel Personnel A Department would however contend that a reading between the lines of the written statement would indicate admission of guilt by the petitioner. For the purpose of consideration of interim prayer, court has gone through the written statement filed by the petitioner. Prima facie, it does not appear that petitioner had admitted his guilt. Explaining the circumstances as to how the transfers were made may not amount to admission of guilt. However, this aspect of the matter needs not detail us at this stage. A perusal of Rule 9(1) of the 1964 rules make it abundantly clear that no order imposing any of the penalties specified in Rule 7 on a top servant shall be passed except after an inquiry. From perusal of the impugn order, it is prima facie evident that no inquiry was held proceeding imposition of penalty of stoppage of 1 annual increment. Moreover, appeal filed by the petitioner was rejected by the same authority who has passed the impugn order of penalty. This is clearly in violation of the principles of natural justice. In view of the above, the impugn order dated 5/11/2015 is hereby stayed until further orders. It was stayed, Your Lordship. In spite of that, Your Lordship, I was not considered for promotion. In spite of the fact that this order was not there at the relevant point of time when promotions were considered. Now, Your Lordship, that was the prima facie view of this Honorable Court, Your Lordship. Now, Your Lordship, make judgment, Your Lordship, 1992 4 SCC 54, Para 6, Your Lordship may kindly.
Yes.
Thus, it could be seen that the word misconduct, though not capable of precise definition, on reflection receives its connotation from the context, the delinquency in its performance and its effect on the discipline and nature of the duty. It may involve moral turpitude, it must be improper or wrong behavior, unlawful behavior, willful in character, forbidden act, a transgression of established and definite rule of action or code of conduct, but not mere error of judgment, carelessness, or negligence in performance of duty. The complaint bears a forbidden quality or character
its ambit has to be construed with reference to the subject matter and in the context wherein the term occurs, regard being have to the scope of the statute and the public purpose it seeks to serve. The police services, this is not required. Now, therefore, Your Lordship, going through this paragraph, Your Lordship, there will have to be some kind of willful conduct on my part. And at least for that, Your Lordship, even the disciplinary authority, while passing the order of punishment, will have to, since there is no inquiry conducted, considering it to be in my admission, that will have to be reflected at least in the order of the disciplinary authority, Your Lordship. Simply by saying that I have, this is in my admission on my part, he cannot impose a penalty, Your Lordship, the disciplinary authority. It must have a forbidden quality. And from the charge sheet, it will have to be come out what is the what rule, what regulation, what has forbidden this, Your Lordship, except saying that.
Now, is it your case that notwithstanding the admission,
Lordship,
there must be a finding by the authority?
Yes, Your Lordship.
So, what law are you proposing?
That is no, Your Lordship. This is from Your Lordship will kindly see that ultimately whether it is a forbidden, whether it is in violation of rules and regulations, whether it is an inadvertent or advertent mistake on my part, that will have to be there will have to be some finding on that. Inquiry is the only way how this finding can be arrived at. But if
because you see, in your where is your written? Where is your reply to this?
page 41, no, not 41. 45, 44, 40, Your Lordship will kindly see in 43, I have categorically denied commission of any irregularity on my part. But after going through those documents, Your Lordship, in 45, there is a change to a certain extent, Your Lordship, in my stand.
What we want to say is that it is not a ground taken that the charges were never specific.
No,
or the charges are vague.
No,
therefore I cannot respond.
No, that is not this case. That's why, Your Lordship, I have not submitted that as a ground also.
So therefore, if that is not the case,
Lordship,
then if you admit,
Lordship,
the authorities will consider that yes, is an admission of the charges level. Therefore, punishment.
Lordship will kindly see that.
Unless you say that even admission by itself will not take away the responsibility from the authorities to arrive at a finding based on reason.
So, Your Lordship will kindly see, Your Lordship, my submission in this, Your Lordship, that ultimately I have made certain admission, Your Lordship, but it is not unequivocal admission, Your Lordship. That is what my case is, Your Lordship. It is if it is at all admission.
See, we are not the appellate authority.
No, not Your Lordship.
We are to see whether the procedure is followed.
Lordship.
In doing so, was there any prejudice caused to you?
Lordship.
There is a charge sheet issued against you. You replied.
Lordship.
The authorities, on the basis of it, decided that yes, he is admitted, therefore the charges of some punishment. The appeal being decided by the same authority is another compartment.
Lordship.
But insofar as the challenge made to the selection process, I mean the inquiry process is concerned, your only ground is that I have admitted, but I did not, there was no mens rea, so as to say.
That's what.
It was inadvertent.
Inadvertent.
Now, was it necessary for them to impose this punishment, or they should have absolved you with a warning? It's to the wisdom of the department.
No, that is wisdom of the department, but Your Lordship, they will have to apply their mind, Your Lordship. And application of mind will have to be reflected from the order of punishment, Your Lordship.
Application of mind is one thing.
Lordship.
And judicious application of mind is another thing.
No, that is there, Your Lordship.
So, application of mind from the particular order, it is apparent that they have applied some mind.
No,
whether
that's-
it was
Now
required
that
to
is
be.
why your lordship will have to see whether from those words, your lordship, those sentences, your lordship.
That's what we are saying.
Lordship.
If your case was on the premise that the charges are vague, I can't answer to these charges.
Lordship, that is not the case.
The allegation made against me do not constitute misconduct under any of the rules. This is not the edifice of your case before the authorities. Your case is that, yes, there was something like that. I was not able to go through. I did not understand. Whatever, there was no loss was, but this is what has happened.
And it is an inverted.
Department has decided that, yes, it amounts to a misconduct, so the punishment. Now, whether a writ court should examine this aspect, that whether this finding is relatable to some misconduct which entails a punishment of this particular nature, or should it have been a lesser punishment, or should the delinquent employee have been discharged without any, the inquiry should have been completed without any finding, is going beyond the parameters normally.
Lordship, in my humble submission, your lordship, having the context of this particular.
Unless you say that no, misconduct, mere admission is not enough. You will have to come on the basis of evidence to show that there was misconduct.
Yes, your lordship. That is what your lordship. Ultimately, your lordship.
On what? Then you have to rely on some authority to show us.
Lordship. Now, your lordship, so far as my first submission in this round is this, your lordship, this does not fall within the ambit of misconduct. Unless it is not fall within the ambit of misconduct, even whether I admit it or I deny it, it makes no difference. And the disciplinary authority cannot inflict an order of punishment, whether it is major penalty or minor penalty. That is my submission, your lordship. And the misconduct for is to be a misconduct act must be of a forbidden quality that is not come out from the charge sheet nor from the order of the disciplinary authority. And that is why, your lordship, in that context, your lordship, to find out whether it is a misconduct or not, the inquiry was necessary, your lordship, which they have not held. This is my case, your lordship. And another judgment is there, your lordship. That also I am relying on, your lordship. That, your lordship, (1999) 7 SCC 409. Para 29, your lordship. Para 29, there is a reference to the earlier judgment shown by me, your lordship. Then in para 40, your lordship. This is important, your lordship, for my case, your lordship. Para 40, when we talk of negligence in a quasi-judicial adjudication, it is not negligence perceived as carelessness, inadvertence, or omission, but as culpable negligence, your lordship. That, your lordship, will kindly note. And my case is that it was an inadvertent mistake, your lordship. This is how the court in state of Punjab versus Ram Singh is interpreted misconduct not coming within the purview of mere error in judgment, carelessness, or negligence in performance of the duty. Now, it will have to be a culpable in nature, your lordship. Mere inadvertence, your lordship, will not come within the ambit of the misconduct, your lordship. And your lordship will kindly, in this para itself, your lordship, in later part, your lordship will find in Hindustan Steel Limited case, it was said that where proceedings are quasi-judicial,
penalty will not ordinarily be imposed unless the party charged has acted deliberately in defiance of law and was guilty of conduct contumacious or dishonest or acted in conscious disregards of his obligations. This court has said that in the penalty will not be also be imposed merely because it is lawful so to do. In the present case, it is not that appellant did not impose penalty because of any negligence on his part. He said it was not a case of imposition of penalty. Therefore, your lordship, ultimately, your lordship, there have to be some finding that this is deliberate on my part. This is forbidden act, and for that inquiry was necessary, your lordship, to arrive at. And even if you are not going to hold an inquiry, then your lordship, these must be reflected from the order of the disciplinary authority.
Yes.
No, sir. Therefore, your lordship, my humble submission, your lordship, with the charges as has been framed by the authority, no misconduct has been committed by the petitioner, and even assuming that he has admitted that he has issued certain order, your lordship, the charge that is in his case, it is an inadvertent mistake. When it is an inadvertent mistake, it will not come within the ambit of the misconduct, and therefore, without holding an inquiry, he could not have been punished by the authority. And even if
The inquiry was held.
No. Where is the inquiry, your lordship?
Whether inquiry, according to you, was held or not is a different issue. But
Lordship.
show cause was issued, you replied.
Then your
Now
lordship,
that is the disciplinary authority has taken a decision.
lordship, that is what your lordship.
That
they
is what
could not-
the rules say.
Rule says, your lordship, if it is an admission, your lordship, rule 9. In that case, your lordship, my humble submission, your lordship, with all the humility in my command, I will submit, your lordship. In that case, there will have to be a finding in the order of the disciplinary authority that this is a misconduct, your lordship.
Which
And-
they have. Not in so many words.
Lordship, that is what your lordship is required, your lordship. Because your lordship, they are taking a decision which have an adverse civil consequences for me. In such a situation, your lordship, they cannot be casual, your lordship, the disciplinary authority. Your lordship, may kindly take up disciplinary and appeal rules for a moment.
Yes.
Rule 9. Your lordship.
Fine.
Here, there is one interesting aspect is there, your lordship will find. Your lordship got it?
Yes. You come to rule 9.4.
Lordship. 9.4. On receipt of written statement of defense, or if no such statement is received within the time specified, the disciplinary authority may itself inquire into such of the charges as are not admitted, or if it considered necessary so to do, appoint for the purpose board of inquiry or an inquiring officer.
So therefore, the
No,
power is there on the disciplinary
that is
authority
what
to
you're looking
inquire.
at. That is why I have not.
So inquire into what? The charges which are not admitted.
Not admitted, your lordship. But your lordship, that is what I am submitting, your lordship. These charges, your lordship, as such I have, there is a not unequivocal admission on my part. Had I said that this is not an inadvertent mistake on my part, your lordship, then matter would have been in a different footing, stand in a different footing. That is not my case, and it is not inadvertent. And that is why that judgment, your lordship, I have relied, your lordship. This must be culpable, your lordship.
That was distinguished in later judgment.
Lordship, that your lordship, don't have that your lordship.
No, you must have now. If it is distinguished, then you have to point out the
So
area.
then your lordship, I'll find out, then point out. Had it been within my knowledge, your lordship, I would have definitely placed it.
No, we are not saying that you are aware and you are not pleased. We have the benefit of some software, therefore we have
Lordship,
been able to find
lordship.
out that it was distinguished in the later part.
Lordship.
Now,
that is one part of my submission. Now, whether your lordship, in fact, your lordship, on this, your lordship may kindly, one judgment, your lordship, I am relying on. AIR 1961 Supreme Court 1070, your lordship, on the part of non-holding of inquiry, your lordship.
is it part of this
Yes, sir.
paper book?
Paper, part. Third judgment, your lordship. Yes. Jagdish Prakash Saxena, your lordship. Para 13, your lordship.
Yes.
May I read your lordship? Your lordship.
Yes, yes. Para 13.
The order passed by the minister shows that he took into account the alleged interpolations in the books kept by the appellant, as well as the fact that Ketulkar and the contractor saw the appellant on the next morning. Now it is clear that so far as these two facts are concerned, the appellant was given no opportunity to cross-examine Ketulkar and the contractor and to show that their story is untrue, nor was he given an opportunity to substantiate his explanation about the alleged interpolation in books. The minister may have thought that the facts to which his attention was invited indicated that the appellant must have been present in the warehouse when the offence took place. But it is of utmost importance that taking disciplinary action against a public servant, a proper departmental inquiry must be held against him after supplying him the charge sheet, and he must be allowed to reasonable opportunity to meet the allegations contained in the charge sheet. The present case preliminary inquiries of a general type were held, and they ended in finding against Ketulkar. The reports did not show that appellant was guilty of offence for which he was ultimately dismissed from service. The delay made in giving the appellant charge sheet, as well as in communicating to him that final order of dismissal shows that authorities did not think the time was essence of the matter, and so there was hardly any justification for not holding a formal and proper inquiry after the appellant was given a charge sheet on October 17, 1951. In our opinion, therefore, High Court was error in coming to the conclusion that no prejudice has been caused to the appellant as a result of respondent's failure to hold an inquiry against him after supplying him with a charge sheet. The departmental inquiry is not an empty formality. It is a serious proceeding intended to give the officer concerned a chance to meet the charge and to prove his innocence. In the absence of any such inquiry, it would not be fair to strain facts against the appellant and hold that in view of admissions made by him, the inquiry would have served no useful purpose. That is a matter of speculation which is wholly out of place in dealing with cases of order passed against public servants terminating their service. Of course, it is termination of service, your lordship, and this is five judge bench, your lordship. There was an admission here also, your lordship, and in view of that, court has held that no useful purpose will be served. Ultimately, your lordship, when adverse consequences is there for me, had it been the case, your lordship, I would not have been deprived from my promotion, your lordship. It may have happened, your lordship, I may not have come before this honorable court also. But it has a cascading effect on my service career. That is why, your lordship, it is more important that they hold the inquiry, find out whether I have committed a misconduct or not, whether it was a willful and deliberate act of negligence on my part or not, and then pass an order.
So here is a case that not a case of there being no inquiry.
No, here there is a preliminary inquiry.
No. In your case,
Lordship.
it is not a case of no
No,
inquiry.
here your lordship also see your lordship in the para 13 last line, search sheet has been submitted.
Charge sheet submitted.
In our opinion, therefore, High Court was in error in coming to the conclusion that no prejudice has been caused to the appellant as a result of the respondent's failure to hold an inquiry against him after supplying him with a search sheet.
Where is the
Only difference is your lordship that admission is not before that pursuant to search sheet, your lordship. It was during a preliminary inquiry, your lordship. That my admission. This is the difference, your lordship. But at the end of the day, your lordship, this will have to be your lordship.
Yes, Mr.
Then your lordship, two more grounds.
Okay.
And
one is the non-supply.
Non-supply of that, your lordship. I have already submitted
Narula.
Your lordship.
Narula judgment.
Narula judgment, your lordship. And then your lordship, this is no judgment has been submitted by me, but the rejection appeal by the petitioner, no more submission is required on that, your lordship. The appellate authority, the disciplinary authority himself, acting as an appellate authority, rejected my appeal.
No, is there a proper appellate authority? Or
yes, your lordship, governor.
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 He is not the secretary to governor.
No, your lordship. Cannot be.
I mean, is he holding the dual charge?
No. At least from the order that is not reflected. And then your lordship will kindly come to your lordship, two more judgment, your lordship. That one 2017 2 SCC 609. Back of lordship. Para 24, your lordship. This my case is that this order lacks reason. In para 24, your lordship. The reasons are the links between the material on which certain conclusions are based and the actual conclusions. They disclose how the mind is applied to the subject matter for a decision, whether it is a purely administrative or quasi-judicial. They should reveal a rational nexus between the facts considered and conclusions reached. Only in this way can opinions or decisions recorded be shown to be manifestly just and reasonable. We therefore are of the considered opinion that the relevant provisions were complied with. Now, your lordship, that's what I'm trying to show you, that this order of the disciplinary authority lacks reason, your lordship. He has not, whether he has applied his mind to the facts, my reply, then arrived at a conclusion, logically deducing from it, your lordship, that has been not been reflected for the order itself, your lordship. And in absence of that, your lordship, this order cannot stand, your lordship. It becomes unreasonable, your lordship. And another judgment on same point, your lordship, para 19, 2010 2 SCC 497. This was on removal of service, your lordship. Para 19, your lordship, mechanism.
Yes, in that.
Lordship. This much, your lordship. Therefore, your lordship, this order needs to be set aside and passed.
Lordship, Madam Lordship, kindly see our affidavit filed by the respondent. Page 10, my lord. Season, my lord, regarding alleged illegal transfer of assistant teachers under SSA, Kolkata district, initiation of disciplinary proceeding against SCS officer Sri Vasudev Das.
Affidavit, please.
page 10. It is the written by the mission director. Assam Sabot to the principal secretary Government of Assam. Inform that what is happening in the Borpeta. And Lordship kindly see paragraph 1, serial number 1. A total number of 391 teachers were transferred from the schools where they were originally posted to other schools during the period of between 20th May 2012 till March 2014. List annexed. Out of 305 teachers are still working under SSA Borpeta district in their new schools. Now, they are posted in somewhere and they were transferred to somewhere, illegally. And second paragraph, appointing transferring authority, contextual teachers, SSA is the mission director of Assam, deputy commissioner may submit proposal.
Is it legally in a sense that there was actually no order passed by the office?
Officer.
Or is it a case that the order was passed, but there were some lapses in getting the order
No,
properly
he is
sanctioned?
violation of the rules. In violations of the existing rules, he has transferred the school teachers, even over mobile message, he directed to join the teachers in some way. Why? What is the interest of it before coming to the Gauhati?
So what was the finding he arrived at in the
Yes,
inquiry?
finding I will come up. Lordship kindly see one thing, page 11, But facts, I want to clear the facts. Some of the teachers have saved SMS received from the ADC come a DMC Borpeta, that is the petitioner. The superintendent of police Borpeta was requested to verify the number of cell phones from where these illegal transfer orders were sent, and he transferred that all the SMS were from the police phone number so and so, against which the subscribe is Vasudev Das, SCS officer didn't ADC come DC. His proof. Other cell phones belongs to other functionaries of SSA have also been verified from the SP Borpeta, but some of the person have claimed the statement their cell phone was used by the Vasudev Das. That means Vasudev Das petitioner used some other cells of other persons. What saying that you were transferred over telephone transfer, over Bible transfers, and what it does, what it does, he by SMS he directed the teacher to join.
Where is a part of the inquiry?
Yes, this is a preliminary inquiry. I will come to the this was preliminary inquiry done by the ADC did Roman Chandra Sharma, and that was after getting it with Roman Sharma.
No, what you are reading is page number 10 and 11.
10 and 11.
10 and 11 is not by the person you say.
No. It is shown director wrote to the principal secretary. The information. What is the information? That I am reading first. He used other cell phone also. Further, they allowed to work the new schools, signing new agreement of the school management committee. And last paragraph also kindly say, this action of the Vasudev Das SCS in carrying out illegal transfer of 391 school teachers without approval of the competent authority amounts to violation of Code of Professional Ethics, breach of trust, insubordination, amongst other faults. The possibility of vested interest and personal gains on the part of the Vasudev cannot be ruled out. Overall, Sri Vasudev has acted in a manner most illegally as civil servant. It may be mentioned that the issue had been taken in the Legislative Assembly during his session February 2014 and had created a forum. The Honorable Minister of Education had in fact given an assurance on the floor of the House to take necessary action. An action has been initiated against the teachers and other SS officials. I therefore request for departmental proceeding may be drawn against the teachers. And Lordship thereafter kindly see. Paragraph paragraph 13, page 13. Joint Director Personal Air Department asked the Borpeta DC to a copy of letter so along with an enclosure received from the mission director. So and to request you to kindly furnish a comments on the matter to the department urgently. Next page 14, Lordship, this is an answer by the Deputy Commissioner. Lordship kindly. 24th of September 2014 to the Principal Secretary. With reference to the cited above, letter cited above, I have the honor to inform you that I have gone through the inquiry report submitted by Ravindranath Sharma, ACS, ADC, Education, and District Mission Coordinator, Borpeta. From the inquiry report, as the government guidelines laid down in this regard, it reveals that Mission Director SSA Assam is the appointing and transferring authority in respect of contextual issues under SSA Assam. But if Basudev Das, SCS, D10 ADC, and District Mission Coordinator Borpeta had transferred contextual teachers without permission from the concerned authority and the Deputy Commissioner Borpeta, which amounts to violation of relevant rules and regulations. As such, I agree with the opinion as suggested by the Mission Director, Assam Sobhakisa Abhijan Mission, Gauhati, by letter dated. So that is the version of the Deputy Commissioner under whom he was working. Seriously, he has performed his duty without informing to the Deputy Commissioner also. And Lordship kindly, and he replied, so-called reply, Lordship kindly see. Page, yes, page 20. He replied to the so-called, that is also in the repetition. Page 20, our affidavit. The submission of reply to the so-cause. Well, this is paragraph 2. That, sir, I was not aware of the provisions of the contract between that teacher and the school management committee of the school. I also failed to understand why TET teachers followed verbal and SMS transfer order of any other officer, including Additional Deputy Commissioner, DMC, in violation of the contract signed by them with their respective SMC of the schools. It is not understood why the finance and accounts officer and district project officer so had prepared salary bills and placed before the DMC SS Borbeta and managed to get this bill countersigned, although the all knew that these were not valid transfer as per contract. However, in the counter signature bills did not cause any pecuniary loss to the government exchequer. He says that my counter signature to the bill is not lost to the government exchequer. But he violated all the rules, my lord. And next, my lord, as part-time officer of the SSA, I did not get sufficient time to go through the details of rules and procedure of SSA, including those relating to transfer and posting of the teacher. I was not properly apprised regarding important circulars so and so. He being a SCS officer, how can he say I am not aware of the rules, I don't want to do this against the rules? How he can say, Balo? And page 21, Lordship Kali, see, CL number 8. Sir, it was not my intention to commit any of the indiscipline and mislead my high authority. It happened inadvertently because of my high confidence level on the subordinate officers and staff of SS Borpeta. Therefore, I request you kindly to consider my above submission favorably and the charge which I hereby admit humbly. The charge which I hereby admit humbly may kindly be dropped in view of my insubordination of next year, and may allow me to discharge my duties also. Because it's the admitted fact that he transferred more than 300 teachers over telephone, malot. He directed the teacher to join there. And you are posting is Borpeta, you go there Mogoldoi. Your posting is Dorong, you go for Trespoor, so and so. How that can be happen? There is the extenders consideration and his personal gain. And the record shows all the statements of teachers also there, records. And 760 pages, some documents are given by the inquiry officer. And that finding all these things, so cause was issued. This is the disciplinary authority to issue the so cause notice. And so cause notice he was asked to whether he admitted. And now, in minor punishment, but when they are decided to inflict minor punishment, personal hearing is also not necessary. So, what is wrong in the departmental proceeding? There is nothing wrong in departmental proceeding. He has committed wrong. But guidelines is there. As per guidelines, there is a district level committee. Either the deputy commissioner is a member, others member. ADC is not member. District commissioner also not member. Procedure is the contextual teachers transfer and rationalization is the procedure. Deputy commissioner will send a proposal to the director, mission director, SSA. And after approval from the director, mission director, that can be done by the district level committee. There are so many persons as there, 6 or 5 persons. That he violating all this number, he had transferred all these things. And after he prayed before the authority that I want to go transfer from the Borpeta to someone else.
Can you show us the records?
The record shows, Manu. I will
Give
show
us
it.
the records.
Yes, Manu.
Give us the records.
Manu,
Give us the records.
I have seen, Manu.
Sorry, UFC. Want to see the record?
No, not so. I will show it, Manu.
Not ready for today.
Manu, one thing is, some synopsis was not actually it is a positive time yesterday. Manu.
All right.
I can
You
show.
prepare it. No problem.
I will prepare all these things, Manu, which paragraph, what is it. And he was also given chance to inspect all documents. He admitted here, yes, I have inspected all documents in presence of this authority. All as the admission fact, but this is a minor punishment. In a minor punishment, so many proceeding, a minor proceeding, but rule says, minor proceedings, my lord, in what is a minor proceeding and minor punishment or major punishment? There, my lord, clause 11. 9 clause 11 minor penalty. If the disciplinary authority having regard to its findings on the charges is of the opinion that any of the penalties specified in clause 1 to 4 of the rule 7 should be imposed, it shall pass appropriate orders. And in every case in which it is necessary to consult the commission shall do so after consulting the commission. In record shows whether APSC was consulted because he was assistant.
That is his ground that you have not given the opinion of the APSC. Not furnished.
That is there in the record, Manu. APSC record says, APSC has admitted, I agree that the proposed penalty can be posed. So, minor penalties, all formalities are not there. They are only sufficient, to issue so-called notice and inform him that we are going to impose a minor penalty. So, that is enough, if they found some materials against this offense. So definitely SCS officer, he cannot say, I cannot know the rules and regulations. He cannot say, my SCS officer, he over telephone using cheap other cells of other person, saying to teachers that you go to this Mongoldo, you go to this Borpeta, you go to this Teresabo. How it can be possible? It's a personal interest. Thereafter, he submitted an application, kindly transfer me. I have some personal difficulty here because all teachers come to the Borpeta, it's come to the notice of the minister. Why he wanted to come from Borpeta to another district after happening of these things. I will produce all these records one by one. Next date of the further hearing.
Continue next week.
As per your logic,
Possible tomorrow.
Tomorrow, I have another matter. Tomorrow, Friday.
Not a good day.
Not a good day. Friday is good day, but next day is our function, I will have to do something.
Rehearsal.
Rehearsal, I have not seen the
first time.
So anyhow, let it next week, and the hearing day. I will clear all these things.
Then let us have it on again next Thursday.
Next time. 18th of
further hearing.
Can it be on 17?
17th, we can keep it on 17th also. In attempt to see. 17th. Further hearing.
I have no. Deep problem.
Mr. S. Botagu, Senior Accountant, assisted by Mr. S. Das for the petitioner, Mr. T.C. Sutia, Senior Government Advocate, Senior Advocate, Additional Senior Government for State, assisted by Mr. T. And MS M. Das for Accountant General. Yes.
Okay.
Timing again 39.
Under Rule 95 procedures. 95.
Rule
95 Lordship. Proceeding superannuation pensions. Office memorandum dated Lordship 29 April 1976.
Rule 95.
Lordship.
Equity. 29 April 1976.
Lordship. Point number 8 Lordship. Surplus Lordship. C Lordship. This Lordship. May I read Lordship?
Yeah.
Provisional pensions to become final after 6 months Lordship. The provisional pension is not intended to continue on a provisional basis beyond the period
You are
of
reading
6
from clause
Clause 8 Lordship. Surplus C.
clause 8.
8 Lordship. Number.
8.
Yes Lordship.
Subclause C.
Yes Lordship.
Okay.
Yeah, Lordship. Provisional pensions to become final after 6 months. The provisional pension is not intended to be continued on a provisional basis beyond a period of 6 months from the date of retirement. If the pension officer responsible for issuing the pension payment order has not finalized the pension case by that time, the provisional pension shall be deemed to have become final, and it will be obligatory for the officer concerned to issue the final pension payment order for the amount of pension and gratuity already calculated on a provisional basis, and the deduction made from gratuity as per sub paragraph A above shall also be released, subject to the provisions of paragraph 9 and 10 below. Lordship. 9 is relating Lordship, last pay certificate, and 10 is relating to adjustment of government dues Lordship. If they are in Lordship, here Lordship, what happened? I am getting Lordship a provisional pension Lordship. It is not final Lordship and
Not finalized.
not finalized.
Why
Yes,
is it not finalized?
As because Lordship, my documents of the nominee is not given.
Okay.
Lordship. So, my wife was made party Lordship in an earlier occasion. This honorable court had.
Is there any mandate that the nominee has to be given?
Here, my lord, actually, whatever 95, I will come little bit Lordship information. 95 days of provision for provisional pension. But 5, 8, 20, 25 notification has come there. Beyond 6 months, you cannot complete. That part is separate. Now, that main pension is to be, regular pension is to be given by department has to forward to AG. But department, when he can forward, he has to give the documents. Wife document. But wife is not giving documents. Thereby, Lordship.
What happens in a case where the person is a bachelor?
Yes, I'm coming. I'm coming. Lordship may pass an order in this particular case that department, as private husband is made parties of cooperating, department may forward pension papers of the petitioner to us, and as soon as it will be ultimately the nominee will be loser, because after date of suppose pension required, she will be in dark. She will be not getting anything. But regarding pension, petitioner's pension, main pension, this pension, the department can forward with an observation that Lordship's order will be required. Otherwise, AG will again say the nomination is given. That's why this may forward. And under another provision, suppose.
Is there any legal certificate with you? No. What is on?
That was not arranged,
No. What I want to say is that is there any son, daughter, unmarried?
Yes, Lordship. Both are married, Lordship.
Both
one
are married.
daughter and one son is there, Lordship.
One last point is there, Miller. Suppose, my lord, during this one, now wife is not handing over these documents. Now, in the meantime, she feels, because his wife, then after some days or some years, she may request the department with her data to forward this one. Accordingly, it will be forwarded, she will get data. Until and unless her documents are not sent, will be not sending, and pension will be, chapter will be closed till he is alive. That is it. Lordship can pass order. I've discussed with his AG also in this regard.
All right.
Pass order, they should forward with the decision.
Lordship, my
And
SAP
one
also
observation, he should give either affidavit or whether he is not giving the full official document. He has to give declaration that he is not giving, or Lordship's order also it should include. It can be.
I think there is an averment here, the affidavit in the writ petition. Have you stated in the writ petition that no documents are given?
Yes, Lordship.
Paragraph?
Yeah, represent. What submitted the
Yes, Lordship. We have already submitted representation before the.
In the writ petition, is there any statement?
Yes, Lordship, there is statement. Lordship.
Point out.
Prayer number 7, Lordship, I have stated, Lordship. His wife failed to respond to the earlier legal notice, Lordship. Thereafter, Lordship.
And it is also there, Lord.
Yes, Lord.
The bottom portion of this project.
It begins in para 5, para 6.
Yes, Lordship.
Third, learned counsel for the parties, the petitioner before the court is was rendering service as a constable under the Director General of Civil Defense and Commandant General of Home Guards. Petitioner superannuated on 29/2/24, and thereafter the petitioner's papers have been forwarded to by the department. He's submitted all relevant documents to the administrative department, namely the respondent number 3, for finalization of his pension. So, however, the column reserved for nominee, the name of the private respondent, number 6, was sought to be entered by the petitioner, requesting the private respondent for all relevant documents and papers, so that the same may be forwarded to the department for incorporation of the same, and finalization of the proposal for being forwarded to the department, to the office of the accountant general. So, the respondent number 6, Srimati so-and-so, is the estranged wife of the petitioner. They were married. However, subsequently, differences occurred between them, and there was some litigation.
No, Lordship.
And the petitioner and the respondent number 6, because of their personal differences, have been residing separately. So, as a consequence thereof, the petitioner is unable to procure the relevant documents about her particulars for being forwarded to the administrative department for inclusion in the column for nominee, the pension proposal of the writ petition. So, he had submitted representations before the authorities. The same has not been. Representation answered, not answered.
Answered, Lordship.
Answered. Where is that?
From page number 27, Lordship. The next are 10.
So you filed representation.
Yes, Lord.
Did you receive any reply?
Yes, Lordship. It is on 10.
27 is to the Director General, not to you.
The copy.
Copy has been marked.
Yes, yes, copy. Copy to.
The commandant of the, what is ASRF? Assam Special Reserve Force Battalion. It is communication dated 11th of March 2025, addressed to the Director General Civil Defense and Commandant General of the Home Guards. Informed that the petitioner has not been able to submit the documents in respect of his wife, namely the respondent number 6, who is his nominee as per the service record, and therefore the pension proposal could not be forwarded in the online portal. Stop. Vera. The respondents have respondent number 5 has filed the affidavit in had made and had and their averments are made that in view of the non-supply of the documents pertaining to the respondent number 6, who is his wife, and shown as a nominee in the pension in the service record, the pension proposal could not be filed. Stop. Under such circumstances, there are, although notices were issued in the matter as far back as 8/9/25, and notices were deemed to be served on respondent number 6, the court permitted petitioner to undertake service by way of dusty. So, the petitioner, in deference to the orders of the court, attempted to serve copies by way of dusty. And para 2 of the said affidavit is stated that although an attempt was made to serve the copies on the respondent number 6 at her residence, in the presence of 2 witnesses, she had refused to accept the same. So, the names of the witnesses, namely what is the first name? Soritro Boisho. Page number 6 of your, page number 38. Annexure to your affidavit or service of notice.
Yes, sir.
Huh?
Soritro Boisho.
Soritro Boisho. And the witness number 2 is shown as Jugesh Hound. So, both the witnesses appears to have signed in the notice, and the notice is returned as not served and enclosed to the affidavit. Stop. Under such circumstances, by the order dated 6/5/2026, the matter was directed to proceed ex parte against the respondent number 6. The learned counsel for the petitioner has referred to when dated 29th of April 1976, issued by the Secretary of the Government of Assam, Finance Department. Stop. At clause 8, para C, it is specified that provisional pension is to become final after 6 months. And the provisional pension is not intended to be continued on a provisional basis beyond a period of 6 months from the date of retirement. The said paragraph is extracted below, page number 59 of the C to The counsel for the respondent it submits that except for furnishing of the particulars for the respondent number 6, namely the wife, estranged wife of the petitioner, relevant documents, the proposal would not be finalized for being uploaded in the return quota portal. It is Mr. C. Burwan, Learned Counsel for the Accountant General, also submits that once the proposal is forwarded from the administrative department to the Accountant General's office, the same shall be necessary order be passed.
Only 2 words may I prefer here. Even this even particulars of petitioner is not for sorry, wife of petitioner is not furnished.
Again, he submits that the proposal can be forwarded even without the particulars of the respondent number 6 in the event. Department of the view that these particulars have not been furnished in spite of request made by the respondent number 6 to the respondent. But having heard the counsel of the party, there is no dispute that the petitioner served in so and so and that superannuated on so and so date. He is entitled to be granted pension under the Assam Services Pension 1969. So he satisfies the conditions specified under 1. Pension rules, and at present he has been granted the provisional pension, but for the documents to be furnished by the respondent number 6, as she is named as a nominee, service book of the or service record of the petitioner, pension proposal has not been furnished, so would not be finalized and forwarded. So, as is evident from the orders passed by the court, that attempts were made to serve copies on that a direction was issued by the court to the petitioner, such an application being made by the petitioner for infringement of his wife as respondent 6. Pursuant to that, attempts were directions were issued to serve copies on the respondent number 6 after notice is being issued. So, statement of the counsel for the petitioner that in spite of attempts being made, the petitioner respondent 6 has refused to accept the copies. The Dozima Court's orders the office note dated 8/1/26 reflects that although the card and answer notice has not been received in respect of respondent number 6, however, delivery details of the consignment as available in the India Post within Court's website reflects that the item has been delivered in respect of respondent number 6. So, in spite of that, service by way of Dusty was directed to be effected on the respondent number 6 by the petitioner, and which the petitioner submits by filing an affidavit of compliance that attempt to serve the notice by way of Dusty, presence of 2 witnesses named in the enclosure to be named in the notice appended to the said affidavit, as the respondent 6 has refused to accept the service of copies and oblige or furnish any details to the petitioner for being forwarded to the administrative department for finalizing his pension stock.
My gratuity is also not really.
Under such circumstances, when there is no dispute that the petitioner was a government servant and had superannuated with effect from so and so date, and he satisfies the requirement under Rule 31 of the Assam Services Pension Rules, and at present he is being provided with provisional pension for respondent number 3 is directed to court to finalize the pension proposal of the writ petitioner without awaiting for the particulars to be submitted in respect of the nominee, which is respondent number 6, and upload the same in the pension portal or NWO, forward the same to the office of the Accountant General, Assam, stock. Upon such proposal being finalized and uploaded, NWO forwarded to the office of the Accountant General. The Accountant General will also, without any further delay, sanction the pension payable to the petitioner. So, it's made clear that the pension payable to the petitioner must include all the other retirement benefits, including gratuity, which the petitioner claims has not been released. So, it is further directed that, notwithstanding the order of this court directing the respondents to finalize the pension proposal and forward it to the office of the Accountant General without the particulars of the nominee, namely the respondent number 6, if at any future date any such application is made by the respondent number 6 for her to be included as a nominee before the respondent number 3 then necessary orders on such application should also be passed. The petition accordingly allowed, disposed.
To forward the documents to the manually, lots of that.
We have given,
criteria is
we
there.
have said either the portal /
That will work out, because
the Accountant General.
sometimes columns are not filled up. Obliged.
I'm highly obliged.
Yes.
I have to reply on the husband also.
Hmm.
So here he is like the husband. On this point, my submission is very limited also. This judgment is not applicable in our case. Our case is now the precedent will come only after the order passed by this by your honorable court. Because our is a peculiar case, Lordship, when we amended the rule on the day of when this was
What is the judgment you have relied?
relying, not I am relying. I'm replying.
Paragraph number?
37 to 40, 45, 47.
Paragraph 30.
37 to 40. Whether it is,
This is SCC.
I supplied the legal.
You are referring to Hemraj.
Hemraj.
What is the, for what proposition?
For the proposition that the
Legitimate expectation.
consideration should be made within time. It says that my lord, consideration should be made every year, and anticipated vacancy should be should also be considered. They have considered the clear vacancies, not the anticipated vacancies, and within time they did not make the subsequently, my lord,
the second DPC, they did not consider our cases. Instead, my lord, the DPC recommended for an amendment of the rule, which is not the duty of the DPC. Which is not a rule making authority.
Yes.
Yeah. Lordship, this judgment is based on a Indian Administrative Service Cadre rules.
So,
So, Lordship, my point is
the
that,
ratio that is we applied.
yes, but here logic, my Lordship, can you go to my our service Lordship, page number 80 Lordship.
80.
80. Here, their only contention is that whether they accrued right or not on the day when the DPC was held. DPC was held. My contention is that on the date, as per rules, as per our service rules, they did not acquire any rights. They did not acquire any rights as per my contention. My simple condition. Lordship, can you go to page number 80?
They have a right to be considered. Unless you say that on the day the DPC was held, they did not qualify the criteria.
But here, Lordship, kindly go to clause 12.6, Lordship. 12.7 also, 12.6 and 7, Lordship. The appointing authority on receipt of the list of recommended by the board. Here, PC was not used. PC, the board, along with the character roles and personal files of the employees, shall consider it for promotion to the next higher cadre and approve the list unless it considers any change in necessary. If the appointing authority considers it necessary to make any change in the list received from the board, it shall inform the board of the changes proposed, and after taking into account the comments, if any, of the board, may approve the list. Finally, such modification, if any, and in such means opinion be just and proper. The list approved shall be called select list. Next part, the inclusion of candidates' name in the select list shall confer no right to promotion unless the appointing authority is satisfied. That my contention is that Lordship, they are saying that they are only while forwarding the name. They have, my understanding is that Lord, they did not have the right to be considered. They did not accrue any right on the name. Lordship,
they do not accrue any right for promotion.
Yes.
But they certainly accrue a right to be considered for promotion.
Right to be considered for the but where they
otherwise, what is the point in having a rules? The rules say that before the end of each year,
appointing authority,
but here Lordship, a likely number of vacancies.
Yes.
So that assessment has to be made.
Yes.
But once that assessment is made, that many number of vacancies, you will have in as per 2, you will have these particulars to be collected and then forward it, request the board to recommend. Board means the selection board.
Selection. But selection board also here amended the rule. Forwarded for amendment of the rule.
No, selection board forwarded, but that is not the job of selection board.
But they did. But they have not challenged that rule also. That is also.
Challenge is a different issue.
But here, Lordship, here that rightly or wrongly, that is rule is there, Lordship, but they have not challenged that part, Lordship. As of now, there is a rule, Lordship. That is gazette notification is there, Lordship.
No, rule is there, no doubt on that. But the question is that on a day when the selection board was required to make
consideration,
the consideration, they did not do so. Rather, they said that no, the rule has to be amended, these, that, all these kind of things. Was it competent for the selection board?
But that part, I'm not, right now, I'm not saying anything regarding that part, but they have not challenged that part also. That rule has not been challenged.
May not be, rule challenge is a different issue.
But here also, that they did it, and this has been approved by the government also. The rule has been approved by the government also. The affidavit I have stated.
What are the facts here in Hemraj?
The situation which this on a friend's case, in this case reflects, Lordship, it is not at par with the judgment, Lordship. So we have on the day of the that is not The facts of the case does not applicable in this handbrush case.
But obviously facts will not apply, otherwise what is the point in hearing a matter?
Yes.
You might as well close it by saying it is covered by this judgment because the facts are similar.
Yes.
On the other hand, if the department decides that no such changes are necessary in the rules, where is the anomaly that notwithstanding the conclusion or a decision by the government that some changes are necessary, we don't want to go for promotion now.
It's not the decision of the department, the decision of the DPC. Actually, kindly peruse the minutes
but
of the two DPCs.
This is the suggestion or a recommendation
Yes,
of
yes.
the DPC.
The
But in terms of that, the rules were amended ultimately.
Proceed kindly peruse the minutes of the two DPCs. The members are same. The 2024 DPC as well as the 2025 DPC members are same persons, my lord. They recommended promotion in the year 2024 on the basis of the same rule. But in 2025, they have recommended for, instead of recommending the cases of the petitioners, my lord, they have recommended for amendment of the rule, which is not the duty of the DPC. But the Chief Secretary of the government directed all the secretaries to fill up all the promotional vacancies. In page, my lord, 31, the writ petition. Where is my lord? You are aware that as per service rule, the departmental promotion committee or selection committee for promotion of the officers and staff of the department and the directorates, commissionerates are to be held before the calendar year so that the promotion reserved by the official and staff can be effected as soon as vacancies in different grades arise. This will also help in improving the administrative efficiency of the government as well as fulfill the legitimate expectation of the government servants. In this regard, we are requested to arrange for all DPCs in the department or in directorate or commissionerate before 28 December 2023, except when there are legitimate difficulties due to order of Honorable High Court, etc. There are DPC selection boards where Chief Secretary is the chairman. I have reserved 3 days, 13, 14, and 15 December 2023 for holding DPCs for different departments. You are requested to submit your proposal immediately to the office of the undersigned for allocating suitable time for holding DPC among the above 3 days. For all those DPCs selection boards where senior most secretaries of the department is the chairman, all such DPCs may be conducted before 28 December 2023 and schedule of the meetings may be intimated to the office of the Chief Secretary in advance. Similarly, all the director commissioners in your department may be directed to conduct DPCs for promotion of their staff before 20th December 2023 and intimate the schedule of the meetings to the office of the Chief Secretary in advance. Your attention is further invited to the fact while there may be certain number of clear vacancies may also occur at different ranks during 2024 due to retirement or superannuation of concerned official or promotion of officer. Such vacancies may also be considered to the extent possible while holding the DPCs for 2024 so that vacancies occurring due to retirement promotion can be filled up immediately as soon as vacancies occur without the need of holding another DPC. Is the letter issued by the Chief Secretary of the
Prior to our rule.
this is in
This letter is prior to our rule.
in consonance with the rule. It says that anticipated vacancies should be considered
This letter also says that, my lord, the future vacancies which are going to fall in vacant in the next year should be considered for promotion. And in the instant case, the petitioners, most of the petitioners are working in the promotional post on in-charge basis without getting the benefit. And the two DPCs, one DPC chairman is same, the member secretary is same, and the, my lord, member, one of the member, 3 persons are same, only one person is different. In 2024 DPC, same DPC has recommended promotion for our bestmates on the basis of the same rule. And our cases were also considered. In 2024 DPC, if you peruse the DPC minutes, it says that you have not alleged malice.
My,
You have not alleged malice against the members.
yes, my lord, I have not alleged malice, but why my lord,
Why it has happened, we don't know, but unless you see, the department is of the view that yes, certain changes are necessary. They have given a
they
view.
can change, but my lord, without that, for that purpose, my lord, they cannot delay the DPC. This honorable court also helped, my lord, in one of the case, my lord, that depend on the plea of amending the rule, DPC cannot be. That judgment the other day,
688.
465/2025. WBC 465/2025.
465.
My lord. Paragraph 7 says, duties of the considered.
Not available. Yes.
Says, my lord, the court is of the considered opinion that while it may be fact that there is a proposal to amend the rule, the same cannot be a basis to hold back the DPC, which is required to fill up the vacant post. Such filling up is in sync with the interests of the public, as the posts are required to fill up in accordance with law as per the requirement of the department and the government. They can recommend for, my lord, suggest the government to take action on the part of amendment, but on that basis, my lord, they cannot hold back the DPC.
You are referring to the Krishna Kumar Sharma.
My lord, Tadar, Talum, and 18 others, my lord. Itanagar bench, my lord.
Give us the citation. What do you do? We'll carry on tomorrow after part 1 list, if possible.